Also, on item number 53, my lord, IA has not been incorporated with the petition, my lord. That may be requisition, my lord. IA may be requisition.
Okay.
May it please your lordship. Lordship, I beg to mention for lordship listing on vacation because intermediate quantity is supposed.
Vacation court listing.
What happened, lordship? What happened? It
No,
was.
listen to me before you.
Yes.
For listing in vacation court, registry will issue a SOP today. According to that SOP, you have to make requisition for listing.
What happened in this case, Lord? Yes.
No, what happened? What I have said, have you understood?
Yes, lordship.
Registry will be issuing a SOP. You have to make requisition according to SOP. Today, they will be uploading that SOP. So listing in vacation code, no mentioning. Yes.
Lordship, I beg to mention for listing a bail application matter today, matter.
No.
Bail matter. Only for calling case ID, nothing else.
Motion item.
Motion. matter.
When have you filed?
Yesterday.
Okay.
One AB and one PA. Both yesterday.
AB not allowed.
BA.
Okay.
And
May I please, your lordship? I beg to mention item number 41. CD was called for and the same is not received.
Heard, Mr. What's your name?
R Hawk.
R.
R Hawk, lordship.
R. Hawk, Learned Counsel for the petitioner. Also heard Mr. D. Sharma, Learned Additional Public Prosecutor.
41
Charge sheeted. You are on,
I am on interim, lordship.
will pass orders when the matter is called. Wait for your turn.
Yes, lordship. I was not aware about the filing of such, lordship.
Your lordship, I beg to mention this item for listing for order item, your lordship. In this case, what happened, your lordship? The direction was given on 22. The matter was disposed of 22, your lordship, and direction was given to appear before the court on 25, your lordship. So,
Okay,
and unlisted, your lordship.
okay.
Much obliged, your lordship.
My pleasure, lordship. My lord, I beg to mention item number 31. Connected with 32, my lord. Yes, your lordship is directed to file an additional affidavit annexing the charge sheet, my lord. That has not been done, my lord. So it come up after vacation, my lord.
Heard Mr. S. M. Mullah, Learned Counsel for the petitioner, who prays for an adjournment. The prayer is allowed. Let this matter be listed after vacation on a date to be fixed by registry.
It is rejected by your lordship, my lord, this matter.
Okay, registry will fix the
My
date.
lord. God bless.
may please, your lordship. Although I beg to mention item number
Connected
17.
Beleke order. kori.
May please, your lordship.
May I
I
please,
beg-
lordship?
I beg to mention item number 17, my lord. It's a writ petition, my lord. There is some difficulty on part of my lord conducting counsel, Mr. R.B. Fukan. Can it be after vacations, my lord?
Yes. Heard Mr.
K. Mohammed.
K.
Mohammed appearing on behalf
K.
of
Mohammed,
Mr. R.B. Fukan.
appearing on behalf of Mr. R.B. Fukon, Learned Counsel for the petitioner, who prays for an adjournment.
My lord,
The prayer is allowed.
can it be on a fixed date?
Registry will fix the
My
date.
lord, I'm obliged.
May I please, lordship? Lord, urgent bail application, lordship, regular bail application, but it is filed, lordship. May I pray for today, lordship, if it is possible, lordship, in
No.
bail, lordship.
When have you filed?
My lord, today it is being filed, lordship.
Then it is not possible.
My lord, to my lord,
No. You mentioned before, pray before the vacation court.
I'm paying for listing of two items for withdrawal, lordship. Yesterday we had filed it. It has already been numbered, and today morning we have came to know that already application has been filed before the session judge. So
Okay,
we want to withdraw it.
okay,
Today,
today. At 2.
But please, your lordship, the urgency of this particular matter, the new matter, it's bail, regular bail. The urgency is that, my lord, the person is behind bars since last 20 days, more than 20 days. He's a director of a company. And that particular company is related with the construction of the flyover in the cycle factory area. Now, what is happening is that the World Cup is on the verge. Like 2 matches will be played here. He's one of the directors. The company is totally defunct because
When have you filed?
yesterday, my lord. We want to take it up as the last item, my lord, because of the fact that he has preferred one bail application, but it got rejected. And now the fact remains is that if he is inside the jail, it is becoming very difficult for the management to run.
No, don't plead your on merits.
No, yes, on the basis that as last item, my lord, so that it can be fixed on vacation report.
Okay,
Last item
okay.
of last.
Recommendation lordship. Bail application 3123/2025, withdrawal.
Okay. Add two. Add two. Which is the item? It is listed today. You
No,
want
lordship.
it?
No, lordship. This matter was listed on 22 September.
No, what is your
Next-
prayer?
Next date on 16/10
What is your prayer? You want it to be listed today for withdrawal?
today, yes, lordship.
Okay.
May I please, your lordship? Lordship, I beg to mention for withdrawal of one item, unlisted matter, that is
Okay, okay, allowed.
highly obliged.
May I please, your lordship, I beg to mention on criminal appeal matters. And kindly list this matter after the vacation for hearing.
No, this
The-
is not urgent.
Arjun, my lord, the petitioner is.
This
given
is
the
not
part-
urgent. Prayer is rejected.
May it please, your lordship. Lordship, I beg to mention item number 29, lordship. Lordship, in this case, CD is not.
Mr. What is your name?
J. Hatimuria on behalf of.
J.
M. Polika.
Hatimuria Learned Counsel for the petitioner. Also Mr. B. Sharma, who learned additional public prosecutor who prays for some more time for production of the case. And the prayer is allowed. Let this matter be listed on 7th of November.
Obliged, lordship.
May I please, your lordship, I beg to mention for listing of one regular bail application, lordship. He was arrested on lordship 23/7/25, and so today lordship 64 days, only for motion lordship sitting.
Okay,
Yes,
okay.
Yesterday I filed.
Allowed.
Deeply obliged.
Lordship, I beg to mention for listing for your lordship for today.
What?
It's an anticipatory bill, lordship, filing number 9360.
When have you filed? Okay,
Second half, your lordship, maybe.
okay, allowed.
Please, your lordship. Lordship, I beg to mention on criminal revision, lordship, on holiday list, lordship.
No.
Unpaid.
You pray as per the SOP to be issued by registry today. No mentioning for listing in vacation.
Obliged, lordship.
Yeah, please. I am not neither for listing nor for. I want to upgradation of item 20 because last week it was there. Did not reach matter. Item 20 at 2 PM.
Why?
Item 20 admission. For upgradation. At 2. If it's not inconvenient to your lot.
No, it will be inconvenient. You wait for your turn. We'll take it up today.
Yes.
You have any personal difficulty?
But it is, no, I don't know. I'm afraid that if you don't reach today also.
We'll take it up today.
Apply.
Lordship, I'm praying for listing one matter, your lordship. It was filed and numbered, your lordship.
What is matter?
Bail application. It was filed and it on 24 and it was numbered also.
Okay. Allowed.
Lordship, I filed a bail application on day before yesterday, lordship, but the same has not been listed. Lordship, today is the last day, if possible,
Okay, allowed.
deeply obliged, lordship.
Can copy, madam.
Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. K. Jain, learned additional public, learned counsel for Customs Department. Call for the scanned copy of the trial court records along with the scanned copy of the connected case diary. Let this matter be listed on 4th of November.
It's been 26 madam.
No,
Much obliged.
May it please, your lord.
Lord, arrested on 5/8/2025. Third seated matter, my lord, pending before additional session judge from special judge Pokso Golaghat.
heard Mr. M. K. Das. learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Charge sheeted case.
As stated, matter, my lord.
Let the records of the scan copy of the trial court records along with the scan copy of the connected case diary be called for. Let also notice be issued to the respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order. 3 working days from the date of this order. Let this matter be listed on 6th of November.
My lord, in my place, my lord, my friend's name may kindly be reflected, my lord. Devanos Dr. D. Dr.
Why?
My lord, this matter, my lord, made a request.
Show the name of Mr. D. Datta
Deeply of
in place of Mr. M. K. Das.
deeply of
May I please order? Let's just kindly pass over for time.
No passovers. Item number
For lordship, commercial quantity lordship CD may be posted.
47. Heard Miss, what is your name?
N. A. Begum.
N.
A. Begum.
N. A. Begum, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Let the scan copy of the trial
No lordship, it's pending investigation.
case diary. Let the case diary be called for. Let this case be listed again on suggested date. Yes, 24th of October.
Pleasure.
48.
None has appeared for the petitioner on call. No, what is the information?
Lordship, after some time lordship.
Okay, we'll take it up after something.
49.
Octo is there, lordship.
None has appeared for the petitioner on call. Let the notice be issued to respondent number 2. No, Mr. B. Sharma, learned additional public prosecutor is present. Let the notice be issued to respondent number 2 in person to the prevailing notification of the registry in this regard. Oxo is there. The
Yes,
petitioner is a lady.
earlier it was rejected by your lordship. Page 21 is lordship.
Issue notice to the respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order. Let also the case diary be called for. Let this case be listed again on 27th of October.
Item 4.
May it please, my lord. My lord, we have filed a criminal appeal against concurrent judgment of conviction passed by the learned sessions judge.
This is a criminal revision petition.
Revision, Your Honor. Revision against judgment of conviction under section 138 of NI Act. My lord, there is some peculiar situation with the IA if that may be taken up.
What I?
Honor, if Your Honor will find the order at page number 54.
I to the. Yes,
Your Honor will find the impugned order at page number 54
of the I.
of the IA. Yes. Your Honor, I have become an under trial prisoner in this NIACT case. I have been behind bars since 27/6/25.
I'm not understanding you.
My lord, what
Which
has-
order you are impugning?
My lord, we are impugning the judgment, but the order by which I was put behind bars, my lord will find at page number 55 of the IA.
Yes.
My lord, what had happened is an order under section 148 of NIAC was passed against me.
On
Thereafter,
the strength of
NBW.
NBW,
Yes.
you were arrested during
Yes.
the trial.
Yes, my lord, the appellate court had issued a non-bailable warrant. Stay was not vacated. I did not pay the amount under 148. The Honorable Sessions Court was pleased to issue a non-bailable warrant of arrest against me and I was put behind bars. And when I was behind bars, the matter was heard and disposed of. My lord, otherwise for today, my prayer is simple. I may be allowed to go on bail.
But otherwise you are convicted.
I am convicted.
Now you are serving out your sentence.
My lord, that we will challenge through this criminal revision petition also. But my lord, the pertinent question is,
Yes, what is the pertinent
my
question?
lord, the pertinent question is whether the Honorable Sessions Judge ought to have put me behind bars for non-compliance of 148 and non-appearing in the appellate court.
Where is the illegality?
Your Honor, otherwise per se there is no bar. The Honorable Sessions Court could have issued the warrant, but the pertinent law would dictate that otherwise the procedure is that stay would have to be vacated, and the trial court would have issued a non-bailable warrant of arrest against me. Here, what has happened is stay was never vacated. The session judge by itself has issued non-bailable warrant against me. My lord, I will not go into that, but just for that, my lord, while this revision petition is being entertained, I may be allowed to go on bail. I will contest it.
We'll issue notice. Why the non-bailable warrant was issued?
My lord, that my lord will find at page number 54 of the IA. May I read, my lord?
Yes.
The appellant is absent without steps. The respondent is represented. Perusal of the record reveals that notice which was sent to the appellant is returned after proper service, but still appellant is absent without steps. I have perused the record and it is apparent that appellant was directed to deposit 20% of the fine amount. However, it is seen that the appellant has not paid the said amount and has not showed any cause for the same and has remained absent without steps in violation of the order dated 3/1/24. Hence, issue NBW against the appellant.
There is no illegality.
My lord, I would argue that two things ought to have been done. One is that stay could have been vacated.
This amounts to vacation of stay, issuance of non-bailable warrant.
My lord, but given the socio-economic nature of the offense, I may be allowed to remain on bail. I have been behind bars
But
since
when you have
1976.
not complied with the condition imposed while granting stay, you cannot enjoy the stay while flouting the order of the appellate court.
My lord, in my very humble submission,
We are issuing notice.
my lord will kindly appreciate my prayer for bail at least once. I would like to submit on one more point.
Heard, Mr. What is your name?
My lord, N. Kothari.
M. Kothari, learned. N. Kothari, learned counsel for the petitioner. This in main revision petition. This revision petition has been filed by the petitioner Abdul Alam, alias Abdul Alam, under section 438/442 of BNSS, impugning the judgment and order dated 14/9/2023, passed by learned. No, impugning the judgment and order dated 37/2025, passed by learned additional session judge Borpeta in criminal appeal number 44/2023, whereby the judgment and order dated 14/9/2023, passed by learned judicial magistrate first class Borpeta, in NI case number 20/2022 was upheld by the said judgment. The present petitioner was convicted under section 138 of NI Act 1881 and was sentenced to undergo simple imprisonment for 4 months and to pay a fine of rupees 5,50,000. And in default of payment of fine, to undergo further simple imprisonment for 2 months. Since when you are behind the bars?
Your Honor, 27/6/2025. So near about 3 months.
Stop. Issue notice to the respondent. The petitioner shall issue notice upon the respondent by registered post with AD as well as by usual mode. Within 7 days from the date of this order. Returnable on, give a fixed date. Returnable on 7th November. Stop. In the meanwhile, considering the fact that the petitioner has already been behind the bars for more than 3 months and the sentence imposed on him is of 4 months only, unless the execution of sentence imposed on the petitioner is stayed, the instant revision petition may become infructuous. Hence, till next returnable date, the execution of sentence imposed on the petitioner is stayed. The petitioner is also allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned judicial magistrate first class Borpeta in connection with NI case number 20/2022. With a condition that in the event of dismissal of the instant criminal revision petition, the petitioner shall surrender before the trial court to serve out remaining part of his sentence, list accordingly. This has become infructuous.
My lord,
You are pursuing the interlocutory application has become infructuous. Or you are pressing for it.
my lord, I couldn't get.
You are given relief in the main revision petition.
My
Now,
lord.
are you pressing for,
No, my lord.
in view of the orders passed in the main criminal revision petition, this interlocutory application has become infructuous and accordingly disposed of.
I was convicted under section 130 of the NI Act and sentenced to pay a fine of rupees 4 lakhs. There was no sentence of imprisonment. I preferred an appeal, my lord, that appeal was dismissed. So my lord, I filed this revision and assailing that order. That's all.
Heard Mr. S. Nawaz. Learned counsel for the petitioner. What is your ground?
Ground, my lord, one of the grounds is that in this case, the complaint, because your lordship will not appreciate the evidence, but the principle is that if there was admissible evidence which was not considered, my lord, that case this court may examine. In this case, there was evidence on our part to show that this money had already been returned. And this money, the complainant had suppressed the fact that the complainant and the accused were partners in a firm. And for the purpose of resignation from the firm, this money was liable to be paid and it was accordingly paid. And there was evidence adduced to this effect.
but that was not considered.
This criminal revision petition under section 438/442 of BNSS has been filed by the petitioner, namely Amir Khan alias Muhammad Amir Khan, impugning the judgment and order dated 22/8/2025, passed by learned additional session judge within bracket FTC Dibrugarh in criminal appeal number 22 within bracket 3/2024, whereby the judgment and order dated 3/6/2024, passed by learned Chief Judicial Magistrate Dibrugarh in NI case number 8/2017 was upheld. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondents within 7 days from the date of this order, returnable after 4 weeks.
There's an IA for suspension.
Now, suppose you don't pay,
There's a default stipulation, my lord, so I will be taken into custody. Default stipulation of 6 months.
any warrant has been issued.
No, my lord, because we have straight away come to this honorable court challenging the appellate court judgment. But it will, because unless and until there's a suspension, my lord, that is the, like.
This interlocutory application has been filed by the petitioner in connection with criminal revision petition number 403/2025. Praying for suspension of the execution of sentence imposed on the petitioner by the trial court. Stop. By the trial court and upheld by the appellate court. Stop. The petitioner has impugned the judgment of the appellate court in the connected criminal revision petition. Stop. Issue notice to the respondent. The petitioner shall take steps. Issue notice to the opposite parties. The petitioner shall take steps for issuance of notice upon the opposite parties by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Give a fixed date after 4 weeks. Returnable on 7th November. Stop. In the meanwhile, in interim, the execution of sentence imposed on the petitioner by the impugned judgment shall remain stayed till next returnable date, list accordingly.
I'm deeply aware.
7 November. In main case also 7 November.
Wait, please, Your Lordship. Your Lordship, have a look at page 18, my lord. 18. Second line. Second line, madam. The accused asks the complainant to lend her an amount of ₹6 lakhs with a promise to return the same within 6 months. Accordingly, the accused paid her an amount of ₹6 lakhs in cash on so and so at about 7 p.m. in the house of the complainant, on the assurance that the accused would repay the same within 6 months in the presence of so and so. But even after a period of 6 months was passed, the accused did not pay. On being approached, the complainant accused issued a check, my lord. And now page 27, my lord.
Yes.
Page 27, paragraph 22, my lord. Considering all aspects, the convicted accused is sentenced to pay ₹7.5 lakhs
as fine amount, and in default payment of the fine amount, the accused shall be sentenced to undergo simple imprisonment for 1 year, my lord. Thereafter, my lord, I preferred an appeal, my lord, that at page 52, my lord, it was upheld, my lord. Page 52, paragraph 32, my lord.
Yes,
In
there are,
view, it was upheld, my lord. In view of the aforesaid principle discussed and in view of the reasons assigned by the trial court and view of the aforesaid discussions reasons, this court feels that the judgment passed by the trial court is just and proper. Now, my lord, my ground here, my lord, before your lordship, my lord, is that, my lord, there is no documentary evidence as regard to the promissory note or agreement, my lord, have been placed before the trial court. And my lord, I have taken a plea, my lord, that the check which I was issued, my lord, it was stolen by him, my lord.
heard Mr. Injay Datta, learned counsel for the petitioner. This application under section 438/442 of BNSS has been filed by the petitioner, namely Suparna Chakravarti, impugning the judgment and order dated 22/7/2025, passed in criminal appeal number 1/2024 by learned session judge Nalbari, whereby the judgment and order dated 12/12/2023, passed in NIE case number 29/2022 was upheld. What is the sentence imposed?
But, sir, 1 year, my lord. In default 1 year.
You have to mention that in the
Yes.
cause title, that
I'm,
rule
I'm-
says
yes, I'm sorry, my lord.
issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on give it 7th November. You have any interim prayer?
Yes, my lord.
In the meanwhile, in interim, the operation, the execution of sentence imposed on the petitioner by the impugned judgment and order shall remain stayed till next returnable date, list accordingly.
I'm deeply obliged.
Item 7.
Item 19.
May I please, my lord? This is 528 application, my lord. This is more in the nature of mercy petition, my lord, than more on merit. May I please, my lord? In this case, my lord, this present petitioner was convicted by the judicial magistrate first class, and he was asked to undergo a sentence of simple imprisonment for 2 months and with a compensation amount of ₹5 lakhs. My lord, I have prepared an appeal against this particular judgment and order passed by the JMFC, and my appeal has also been dismissed. Thereafter, my lord, a revision petition was prepared, and revision petition before the Honorable High Court was admitted subject to deposition of ₹1,50,000. And subsequently, my lord, my revision petition has also been disposed.
Then this is not maintainable.
No, my lord, I have a very simple and limited prayer in this particular petition. Thereafter, my lord, I approached the complainant, my lord, to pay the remaining amount of rupees, compensation amount, 3,50,000. But he has refused to accept so. So my limited prayer in this particular petition, let me deposit the remaining part of the compensation amount.
No, this question cannot
3,50,000.
be,
My lord,
after your appeal and revision dismissed,
dismissed, my lord.
you don't have any remedy in this, before this court.
No, if there is a, suppose, had there been a compromise arise between the accused and the complainant, then my lord may consider, because
But it is not a
the
case
fresh
of,
cause of action would arise, my lord. So my limited, let me deposit 3,50,000, and the execution of warrant may be kept in abeyance. This
No.
is my humble prayer.
not after dismissal of this prayer you could have made before the revisional court. Revisional court, and
Totally understand. Even if
you
we
don't
now-
have any legal
But
remedy now.
under my lord negotiable instrument act, a civil liability has been converted into criminal offense. Now, if I put behind a bar, my lord, what is the benefit the complainant would derive?
That is the law.
No, my lord, let the notice be issued at this stage. Let the,
This is not a case for issuance of notice. No notice.
my lord, may kindly issue notice at least in this case, so a possibility could be left to, that a compromise could be arise between the parties.
No, you satisfy this court regarding maintainability of this petition. We are fixing a date, keeping it open without issuing notice.
And
in the
meantime, he may
Yeah.
stake to the, and give a stake to the responding mother.
Heard Mr. B. Dekar, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner Debesh Goswami, impugning the judgment and order dated 3/5/2024. 3/5/2024 or 25?
My lord, I have not impugned any order in this matter, my lord. My prayer is very simple in this case. Let me deposit remaining balance of 3,50,000 rupees. And the execution of warrant may be kept in abeyance till the disposal of this particular.
Praying for praying for
My lord, may kindly come to page 13 and my prayer portion, my lord. I have not impugned any particular order or judgment.
praying
this
for
Second prayer, my lord.
warrant has been issued against you.
Yes, my lord. Warrant has been issued again.
Praying for issuance of praying for stay of the warrant issued against the petitioner
By order to 10/5/2024.
on 10/5/2024.
2024.
24.
Yes, my lord.
24 months.
24.
My lord, several attempts has been made to settle a compromise between the accused and the complainant, my lord. So considering that, my lord, I may be allowed to deposit 3,50,000 rupees.
There is no bar in, there is no leave of court is required. You can deposit today also.
No, my lord.
Why
it is
have you
there.
come to the
The
court?
accused will have to personally appear before this court. Without his appearance, my lord may direct me to deposit 3,50,000, I will deposit that amount.
No, why
before it
the
comes.
direction, revisional appellate court has directed you, trial court has directed you, appellate court has directed you,
No, my lord,
revisional
if
court
I
has directed you.
personally go and appear before the, on a learned trial court to deposit 3,50,000, there might be a possibility of incarceration. So that is why, my lord,
No,
a specific order may
No.
be passed directing me to deposit 3,50,000. I will deposit, my lord, 3,50,000 rupees before the trial court or before the registry of Guwahati High Court, my lord.
no. You comply with the order of the trial court. Illegally. 24. Stop. And allowing the petitioner to deposit rupees 3,50,000 before the trial court. Stop. It appears from record that by order dated 15/10/2013, the petitioner was convicted under section 138 of the Negotiable Instrument Act and was sentenced to pay a fine of rupees. What was the fine?
5
What-
lakhs. Compensation amount of rupees 5 lakhs.
Pay compensation amount of rupees
5 lakhs.
5 lakhs. Five lakhs,
Yes, my lord.
then
No, then my lord may kindly come to page 34. Because at the time of admitting the revision petition, there is a condition that unless I pay 1,50,000 rupees, then my revision petition will not
that
be
you have
admitted.
paid,
Yes, my lord. During that time, 1,50,000 rupees has been deposited by
pay
the petitioner.
fine of rupees 5 lakhs. And imprisonment was there,
My lord,
any sentence for him, where is the order of the trial court?
order of the tribunal, my lord, I have annexed the judgment of the trial court.
Where?
That my lord will find at page 15, my lord. Page 15. But the order part is not available over here. My lord will find it at
Where have you mentioned that sentence?
No, my lord may kindly come to page 25. The sentence part is reflected in the order of the High Court. My lord may kindly have a look at the para number 3, page number 25, my lord. Para 3, my lord may now kindly come to page number 26. Here it is reflected that
5 lakhs
5 lakhs amount.
and
And the check amount is 2 lakh 50,000.
and also was sentenced to undergo simple imprisonment for 2 months. The petitioner was also imposed simple imprisonment for 1 month in default of his paying the compensation amount. Against the said order of the trial court, the petitioner appeared before the petitioner preferred an appeal before learned additional session judge FTC, which was registered as criminal appeal number 200/2013, which was also dismissed. Against the order of dismissal of the appeal, the petitioner again preferred a criminal petition, criminal revision petition, which was registered as criminal revision petition number 452/2017. At the time of admission of the criminal revision petition, the petitioner was directed to pay an amount of rupees, deposit an amount of rupees 1,50,000 as condition precedent for admitting the said revision petition, which the petitioner had deposited. However, ultimately, by order dated 3/5/2024, the revision petition was also dismissed. Now, by filing this petition under section 528, we are dismissing it.
My lord, let me have another opportunity to convince my lord that this petition is maintainable.
This is
Let
not,
let the matter be fixed, my lord, immediately after the vacation, my lord. I will satisfy this honorable court.
the petitioner has prayed for stay of the warrant issued against him and also prays for allowing the petitioner to deposit 3,50,000 before the trial court. Stop. this court, when a question regarding maintainability of this instant criminal petition was posed by this court, learned counsel for the petitioner prays for some time to make his submissions and bring authorities in support of his submission regarding maintainability of this criminal petition. The prayer is allowed. Let this matter be listed on 4th of November.
Can I be fixed little early, my lord?
On 15th of October.
Deeply okay.
Sorry, my lord, in item number 49, my lord, I was lagging some other court, my lord. Your lordship is pleased to call for the case diary and the notice has been issued. Simply, my lord, your lordship may kindly reflect my name, my lord.
Item number 4.
49, my lord, supplementary.
49, Mr. A.K.Z.
SKJ, my lord.
SKZ. Show his name. Okay.
Deeply obliged.
May I please, your lordship?
Yes.
My lordship, I am retired zonal officer of, zonal manager of IndusInd Bank, my lordship. I was retired on 29 to 2020. And FIR was filed on 28/11/2019. That is after 1 year. So after 1 year, the other zonal manager filed the FIR by stating that some on the basis of some court's document, a loan has been sanctioned, my lordship. So, my lordship, my contention, my FIR is on page 17, my lordship, can be seen.
What is the status of the FIR? Charge sheet
Charge sheet has been filed. We have challenged the charge sheet. Yes, because, my lordship, in the FIR, my name is not reflected. I am the zonal manager. The zonal level credit committee, my lordship, after recommending the loan proposal, I am the sanctioning authority, and
What is your ground for challenging charge?
my ground is challenging because I have no mens rea in this criminal act, my lordship, and moreover, the zonal level credit committee, which is the competent authority, my lordship, after considering the proposal of the branch manager.
Heard Mr. S.B. Laskar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS. What is the stage of the trial?
Stage, my lordship, it is on the charge has not been issued till framed till date, my lordship.
You have appeared before the trial.
Yes, I have appeared and I'm seeking.
528 of BNSS, praying for quashing of the proceedings of PRC. What is the case? PRC case number
Yes, my lordship.
1422/2021, pending before the Court of Learned, Chief Judicial Magistrate, Kamrup. Call for the scanned copy of the trial court records as along with the scanned copy of the connected case diary. Also issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
My lordship, interim order really because
No interim.
because my lordship,
No interim.
no, I am the zonal manager, my lordship. I have annexed all the documents. My lordship, kindly see the document.
No interim.
I live.
Petition for quashing of the proceeding, lordship. Charges had been filed, lordship,
Charge sheet submitted.
submitted, lordship.
Why are you challenging the charge sheet?
The lordship will find the charge sheet at page 30, lordship. There are 9 accused persons. The prime allegation against the accused number and
No, what is your ground? Why are you challenging?
already, lordship, against the prime accused person, I have annexed the orders, matter has been quashed. And 2 others, the bank official, the matter has been stayed. I'm an employee of the accused number 1. We are the petitioner number.
Where is the quashing order?
Order, lordship will find at page 50, lordship will find. Anil Tiwari, he was the general manager and he sanctioned and approved the loan. Page 50, Lordship will find.
Who are you?
I'm the employee of accused number 1, Panidhar Talukdar. He's a builder, Lordship. He sold land flats to accused number 2. This petitioner, Anil Tiwari, he approved the loan. Against them, Anil Tiwari, the person, the officer who approved the loan, and the person who sold the flats, Panidhar Talukdar, against them, proceeding has been quashed. Now, Lordship will find another order is there, Lordship, page 59.
What was the accusation against you? What was the
Accusation against that,
allegations?
accused number 1, he issued 4 number of checks in our favor because we were the employee. For official discharge of duty, they issued the 4 numbers of checks. That much is it. Neither we were involved in processing of the loan or forgery cases registered under section 420, 468, 406, breach of trust, forgery, and cheating. There is no involvement in the processing of loan application. Neither it was approved in our name, nor the loan amount was credited in our account. Loan amount was credited in the account of accused number 1. Accused number 1, against the accused number 1, the case has been quashed. Against the accused number 7, who has approved and sanctioned the loan, against him, the case has been quashed. The 2 other bank officials, the proceeding has been stayed. We are the employee of accused number 1, the builder. And only allegation in the charge sheet is that 4 numbers of checks were issued in our favor, drawn by the accused number 1 to discharge the official duty. That much is that. Question matter may be fixed along with this.
Heard Mr. Zaid Alam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner.
2 petitioners.
Petitioners, namely Solin Roy and Saroj Sharma, praying for quashing of the you are praying for quashing of the proceedings of GR case number 692/2018 pending before the Court of London, Additional Chief Judicial Magistrate, Kamrup Metro. Stop. Learned counsel for the petitioner has submitted that charges are framed.
Frame.
When?
I have an act order, Lord, you will find that.
Learned counsel for the petitioner has submitted that in the instant case, in the aforesaid case, charge sheet was laid under section 420/468/120B IPC against how many accused persons?
9.
Against 9 numbers of accused persons, including the present petitioners. He also submits that by order dated 17/7/2019 and 5/9/2019, charges were framed against the above named petitioners under section 420/468, read with section 120B of the IPC. Stop. The petitioners are also impugning the aforesaid orders of framing charges. Learned counsel for the petitioner has further submitted that in the meanwhile, a coordinate bench of this court has quashed the proceedings of the aforesaid case, qua the accused number 1, namely Anil Tiwari.
Accused number 1, Panidhar Talukdar. Charge sheet. Against
Against,
Fanidhar Talukdar and
against whom?
Anil Tiwari, both. Accused number one and 7. Anil Tiwari is accused number 7 in the charge sheet. And accused number 1 is Fanidhar Talukdar. Against them, matter has been quashed.
Where is the order of Fanidhar Talukdar?
Lordship will find page 50 is Anil Tiwari, joint order was passed. Next, Lordship 31 is Fanidhar Talukdar.
Okay, accused number 1, Fanidhar Talukdar, and accused number 7, Anil Tiwari, has been quashed by order dated
1/5/25.
1/5/25, passed in criminal petition number 495/2022. Learned counsel for the petitioner has further submitted that another charge sheeted accused, namely accused number 9. What is his name?
Accused number 9 is Pranjit Kumar Bhuya.
Where is the order?
Lordship will find at 59, page 59.
Another accused, that is accused number 9, namely Pranjit Kumar Bhuya,
And Bharat Singh, accused number 6.
and one Bharat Singh, accused number 6, had also approached this court by filing a praying for quashing the proceeding, and by order dated 14/7/2025,
Proceeding has been stayed in
the
respect of that.
proceeding against those accused persons have been stayed. Order dated 14/7/2025, passed in criminal petition number 746/2025. The proceeding has been stayed. And when is the next date fixed?
There is an order to list the matter after 4 weeks. Matter has not listed. Both the matter may be tagged together.
Okay. In view of the submissions, let the scanned copy of the trial court records along with the scanned copy of the connected case diary be called for. Let this matter be listed November of that date of ROPC. Let the matter be listed on 14th November along with criminal petition number 746/2025. However, in the meanwhile, in interim, considering the facts and circumstances of this case, the proceeding of GR case number 692/2018, so far as it relates to the present petitioners, shall remain stayed till the next returnable day. List accordingly.
Deeply aware. Deeply.
May I please allow? My lord, here, my lord, we have challenged the order, my lord, whereby, my lord, the investigation, my lord, in a case, my lord, has been extended, my lord. Your lordship will kindly come to page 25 is the impugn order, my lord. That is the petition, my lord, and your lordship will find the order at page 26. I am reading out, my lord. Since the petition filed by learned so and so, under section 480 of BNS is seeking bail of accused so and so, who
What
was
is the illegality?
my lord, yes, my lord. Illegality is that, my lord, this is by the investigating officer. In fact, my lord, your lordship will kindly come to page 25. It is the petition by the investigating officer seeking, my lord, extension of the investigation, my lord. So that is not the mandate. In fact, my lord, proviso to, my lord, subsection 4 of 36A, my lord. So it mandates that it should be by the, my lord, public prosecutor.
No,
The report.
that is for extension of the
Yes, yes.
period of detention, not for investigation.
That is, in fact, my lord, if investigation is, my lord, extended, then there will be detention, my lord. In
No,
that,
there is a difference.
yes,
That the provision which you are referring to, that is 36 What is the provision?
Provision is your lordship will, section, proviso to my lord 36
A,
4A, yes, ma'am.
that 36. A4,
A4, yes, ma'am.
that relates to only NDPS.
It relates to my lord investigation, ma'am. Extension of investigation. In fact, my lord, there is a coordinate bench, my lord, order, my lord. My lord, laying down the, my lord, exact.
No, it relates to the extension of the period of detention, not investigation. If investigation is not completed, detention period may be extended.
Yes.
So by this order, detention period has not been extended.
And in fact, this is, my lord, your lordship will, if your lordship, goes through this 25, page 25, my lord, this is an application by the, my lord, investigating officer, my lord. So this is in violation of this proviso to subsection 4 of section 36A, my lord.
You have completed 6 months.
Yes, my lord. And in fact, my lord, 180 days, my lord, that is, I was arrested on, my lord, 27/12/24, my lord. And my completion, it expires on, my lord, June 24, my lord. And my lord, this is 25/6/25.
Last two lines.
Yes.
And report of the IO, where is allowed. So, PP and report by the IO.
What prayer is allowed?
Yeah.
Investigation period is extended.
It's not so- or some leader matter. It can be extended on the.
What can be extended under 36A4? It is the period of detention which may be extended. Detention may be extended. But there is no order for extension of period of detention. Only regarding investigation.
Provided that if it is not possible to complete the investigation within the said period of 160 days, the period could may extend the said period up to 1 year. The report by the public prosecutor indicating the progress of the investigation.
Period of detention can be in.
Let the record come. My lord.
Because there was no prayer for extending the period of detention. No. Investigation may continue even after lapse of that period. Only period of detention has to be extended.
My lord, your lordship will kindly come to page 28. There is an order by the coordinate bench, my lord. While, my lord,
No, law is clear
yes, ma'am.
that there has to be a report of the public
prosecutor,
prosecutor for extension of the detention period,
Yes, yes, ma'am.
not for extension of the investigation.
Yes.
There is a difference because investigation may continue even after you are allowed to go on bail. Only if detention period is required to be extended.
Yes.
See, we are calling for the case.
In fact, my lord, this is the order passed by the coordinate bench at page 28. For a moment, my lord, in the same similar fact, my lord, there was an application by the investigating officer. In fact, my lord, there was no report from the public prosecutor.
No, we'll examine. You heard Mr. J.C. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner Minarul Haq, impugning the order dated 26/6/2025 passed by learned Sessions Judge Morigaon in NDPS case number 40/2025, corresponding to Morigaon PS case number 353/2024. Stop. Let the scanned copy of the records of Morigaon NDPS case number 40/2025 be called for. Along with the case diary of Morigaon PS case number 353. Date, reopening date. Release this matter on 15th of
May I
October.
pray stay of this order, my lord, because of
No.
this, my lord. if it
This
is
has
filed,
only extended the investigation.
Yes.
And
So that's why, my lord, I am in illegal detention because of this illegal order, my lord.
you may pray for bail.
That's
They-
why, my lord, I will definitely pray for bail unless it is on, my lord, record. If it remains, then, my lord, my bail
It
prayer will
has
be-
not extended your detention period. That is my understanding.
Yes,
And you have not come against there is no extension of detention period. Only investigation has been extended. So you may go pray for bail, and this is only order challenging the extension of investigation period. That we will examine.
520,
Let the-
let the record.
You have other recourse.
In fact, my lord, my bail petition is also pending, my lord. Yeah.
Pursue that bail
Yes.
petition.
Item 11.
I am deeply obliged.
May it please your lordship. Lordship, this is 528 application under BNSS for quashing of criminal proceeding arising out of a complaint. Which is registered as CR case number 243 of 2022. Here, before I take your lordship to the impugned complaint, here petitioner 1 now presently working as deputy superintendent of police posted at Bongaigaon, and the petitioner number 2 who has retired as sub-inspector of police from Udarban. Now the gist of the case is such, lordship, these two petitioners, petitioner 1 was posted at Udarban PS in the year 2020 as officer in charge, and the petitioner number 2 was the sub-inspector in that Udarban police station. And lordship would be pleased to find the acquisition.
Under section, cognizance has been taken under section.
I think that before that the complaint.
That you have to mention in the cost title itself. Why have you not mentioned in the cost title? Under what provision cognizance has been taken?
Cognizance has taken under this lordship. The
There is-
King complained it as at page 34 lordship. Complaint lordship. Here petitioner 1 is accused 1 is the petitioner 1, and accused 2 is the petitioner number 2 lordship. And the straightway to the acquisition lordship.
Where is the
May-
order of taking cognizance?
Page 43, last page, ma'am.
Page 46 lordship is the typed order. No whisper. Here lordship, may I take your lordship to the order lordship? Complainant is present, complainant witness namely so-and-so, so-and-so, so-and-so are present. They are examined as C2, C1 under section 202 CRPC. Peruse the record along with the complaint petition statement of the complainant under 200 CRPC, is witness under 202 CRPC. On such perusal, it appears that there are sufficient grounds to proceed with this case against the accused persons, namely C so-and-so, the Ashish Uttadhar and Devendra Kumar Boisha, so-and-so, 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 other accused along with other 14, 20, 20, 23 numbers of 24 numbers of accused. under section 120B, 326, 506, 447, read with section 34 of IPC. Hence, cognizance of the offense is taken against the
Where is
aforesaid
the, what
accused.
is the error?
Error, now, Lordship, here I was discharging for this 218. This was before 197 CRPC. Not a mandatory violation of that section, Lordship. Lordship, I'll take your Lordship to 218 of the BNSS, which deals such as, Lordship, the prior government sanction before a before a court can take cognizance of an offense committed by a judge, magistrate, or public servant in the discharge of their official duties. The provision ensures public servant from vexatious complaint and provides mechanism for determining if the process if the proposed sanction is warranted. That is the mandatory compliance, Lordship. Now, this petitioner, he being a public servant, he while discharging his duty, Lordship. Now, where is his duty? I'm placing that, Lordship. For that, Lordship, I have to take your Lordship to again the complaint filed by the here. The gist is that during the pendency, the informant, there were two cases. One is Udarban PS case number 84/2020, filed by one.
Yes, Mr. Parashar.
Lordship, there were another this Lordship 148/2020, and these two cases has been registered. And when the petitioner was acting as an officer in charge of that police station, Lordship, so he because of the registration of the case, the informant who is now the complainant in the accused person who is now complaining in the present complaint is agreed, and this complaint petition has been filed. So while the taking cognizance, magistrate has not at all followed the mandatory compliance, Lordship.
But
That is why-
cognizance was taken on 3/2024. Giving direction to APR 5/4/2024. Now in September 2025, let the notice be go in complaint case, and record be called for,
Lordship, I have a prima facie
what is the
very good
present
case,
status,
Lordship, Lordship
We
means
will examine.
stay the proceeding. I am not asking for the entire proceeding in respect of the present petitioner, Lordship. If your Lordship,
Whether the act was done in discharge of your duty or not.
that, why should I be harassed? Now, I used to stay, now I'm posted at Bongaigaon, and the other person, other petitioner, Lordship,
Third, Ms. T. Som, learned counsel for the petitioner. Also, had Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely Asit Sutradhar and Dhirendra Kumar Bashya, who are praying for quashing of the proceedings of CR case number 243/2022, which was filed by the respondent number 2. Learned counsel for the petitioner has submitted that the court of learned which court took cognizance?
official magistrate,
Court of learned judicial magistrate first class,
Silchar.
Kachar Silchar, by order dated 3/2/2024, took cognizance of offense under section 120B/326/506/447 of the Indian Penal Code against the petitioners and 24 other accused persons. Learned counsel for the petitioner has submitted that the petitioners on the date of alleged offense were posted as police officers in which police station?
Udarban Police Station.
Udarban Police Station. And the alleged offense was, and the offense alleged against them has been apparently done by them while they were discharging their official duty. And therefore, she submits that before initiating criminal proceedings, prosecution sanction, prior prosecution sanction ought to have been obtained. However, in this case, no prosecution sanction for initiating the proceedings against the present petitioners were obtained. Stop. Issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with ID as well as by usual mode within 7 days from the date of this order, returnable on 6th of November. 6th of November. Let also the scanned copy of the, it is pending scanned copy of the trial court records be also called for. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioners, what is the stage?
Yes, appearance stage only.
The personal appearance of the petitioners before the trial court shall be dispensed with. You appeared through lawyers. Shall be dispensed with till the pendency of this, till next returnable date, list accordingly.
I'm deeply obliged.
Item 12. May I please? My lord, discuss, my lord, have challenged the issuance of NBW, my lord. Kindly see the order, my lord, page annexer, page 19, my lord. Whereby, my lord, cognizance has been taken and issue summoned, my lord. Cognizance has been taken, my lord, under section 360 AIPC, my lord. Thereafter, my lord, kindly see page 20, my lord. Accused is absent. Someone issued has returned with a report that the said address of the accused falls under Hobbyganj PS of South Salmara district. Since the report, hence issue fresh summon to the new address, my lord. My lord, my address is, my lord, Hobbyganj is correct, my lord, but South Salmara district is not correct, my lord. I am under Dhuri, my lord. And therefore, my lord, someone has not been summoned, my lord. On the very next date, my lord, my lord, kindly see impugn NBW, my lord. My lord, NBW has been issued against me, my lord, without recording the reason, my lord.
Okay. When is the next date fixed?
Next date fixed, my lord, 10/11/25, my lord. Page 24, my lord.
Heard Mr. A. Hussain, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner impugning the order dated 30/8/2025 passed by the Court of Learned as Subdivisional Judicial Magistrate S. Sonitpur in GR case number 293/2025, whereby non-bailable warrant of arrest have been issued against the petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner has not received any summons from the trial court in the aforesaid case. He submits that by the impugned order
15/2/2022, sir. Page 22.
in 2020,
2020 my lord,
Yes,
before
2020.
pandemic my lord, before COVID pandemic.
then what has happened now?
Now, my lord, kindly see page, my lord, 24, my lord.
Still in that.
It is, my lord, order, my lord, 38/2025, my lord.
क्या लिखा? By the impugned order, the trial court, without ascertaining due service of summons issued to the petitioner, had issued non-bailable warrant of arrest. Learned counsel for the petitioner submits that the next date in before the trial court in GR case number 293/2017 is fixed on 10/11/2025, and the petitioner is ready and willing to appear before the trial court and to cooperate in the trial. However, he seeks some protection as non-bailable warrant of arrest has already been issued against him. So I have considered the submissions made by learned counsel for both sides and have gone through the records of the case. It appears that before issuing non-bailable warrant of arrest, the trial court did not ascertain as to whether summons were duly served on the petitioner or not. There is no report of due service of summons on the petitioner. In any view of the matter, as the petitioner is ready to appear before the trial court and face the trial, this criminal petition is disposed of with a direction to the petitioner to appear before the Court of Learned SDJM Sonitpur in GR case number 293/2017 on the next date fixed, that is 10/11/2025. Stop. To facilitate his appearance before the trial court, the non-bailable warrant of arrest issued against him by the trial court shall remain suspended till 10/11/2025. Upon his appearance before the trial court, the petitioner may seek any relief to which he is legally entitled to. This criminal petition is accordingly disposed.
Oh, bless you.
Item 13.
Made the motion. Flushing of tax student proceedings, my lord. The petitioner is, my lord, he was appointed as supervising officer in an examination. When he expelled one student, my lord. And ultimately, after, my lord, about 7 days, my lord, the FIR was lodged that 354A, etc. Charge was filed, your lordship will find charge sheet. FIR is page 21. And charge sheet filed after, my lord, 6 years, my lord, 22. 15/6/22. Charge sheet.
What is your ground?
The ground is, my lord, purely, my lord, manifested with ulterior motive, my lord. Nothing, your lordship will find he is a in charge principal of the college, and his appointment is, your lordship, can page 19. He was.
Okay, we'll call for the records. Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. A.S. Akan, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Amir Ali Sheikh, praying for quashing the charge sheet filed in
And also proceedings of PRC case.
praying for quashing of the proceedings of PRC case number 5912/2022 pending in the Court of London, Judicial Magistrate First Class, Dhubri, Assam. Let the scan copy of the records of trial court along with the scan copy of the connected case diary be called for. Let also notice be issued to respondent number 2 by registered post with AD as well as by usual mode. The petitioner shall take steps for issuance of notice upon respondent number 2 within 7 days from the date of this order, returnable after 4 weeks. Listed.
14.
Lordship, this petition is for quashing of the FIR dated 19/10/2021 and of the charge sheet number 207 dated.
Charge sheet also.
Also, is there a notice has to go.
Heard Miss M. Bora. What's your name?
AFs.
A.N. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. This application under section 528 of BNSS has been filed by the petitioner Akram Ali, praying for quashing of the proceedings of special POXO case number. What is this special POXO case? What is the case number?
In the prior portion, they have mentioned a special case number 78/2022.
78/2022, pending before the Court of London.
Special Judge North Salmara Abhayapuri.
Special Judge North Salmara Abhayapuri.
It is fixed on 6/12/2020.
Issue notice to respondent number 1, respondent number 2 and 3 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 7 days from the date of this order, returnable on, yes, 6th of November. Let also the scanned copy of the trial court records along with the connected case diary be called for. List accordingly.
Item 15.
Wait, please, your lordship. This is a petition under section 528 of the BNSS, praying for quashing and setting aside of the complaint, which lordship will find at page 125. If I read this, lordship, it will be a case that it is a purely a case of civil dispute. There is no element of any criminality. So I am Ojen Jamo of Arunachal Pradesh, lordship. The affair is lost by my business partner before the
Page number 1.
page number 125. So it has been lost before the officer in charge of East Police Station, Dimapur. May I read it, lordship, because this is my case. Subject complaint against Sri Ojen Jamo of Samsung Village, Geku, Upper Siang, Arunachal. Most respectfully, I have the honor to state that your humble complainant has entered into an inalienable agreement on 21/10/2015 with MSRJ Enterprise, represented by its proprietor, Ojem Jamo, so and so, for carrying out a contract work worth 14 crores pertaining to construction of OFC optical fiber cabling, BSNL, defense project from Panging to Tuting in the state of Arunachal under the establishment of A to Z Infra Engineering Private Limited, Gurgaon.
mention may be made herein that I met Sri Ojen Jamo in the early part of 2015 through one of my friends, namely Tasen Tamil. Over a period of time, we became good friends. Then in the month of July 2015, when I was in Dimapur, Mr. Ojen Jamo telephonically called me and proposed to pursue and execute the mentioned project in partnership. And the following weeks, we continued to discuss about the project over phone. In August 2015, Mr. Ojen Jamu told me to come to Delhi to pursue the project, and accordingly, I went to Delhi, discussed and pursued the project. After returning back to Dimapur, I started transferring money on the project to his bank account listed in Annexure 1. That on 21/10/2015, the said agreement was duly registered before Notary Public, and as per the agreement, I have paid altogether a total amount of 1,95,07,000 only to Ojen Jamu through bank deposit and cash payment on various occasions for the construction of the said OFC in Arunachal Pradesh. As per our agreement, Sri Ojen Jamu was ought to pay me upon receipt of the said of the first and second running bill. However, despite my repeated requests on several occasions, Sri Ojen Jamu did not pay me my due share, including my said investment amount, and ignored my telephone calls, changed his telephone number, and shown reluctance to return to the aforementioned amount. My attempt to communicate with him through intermediaries have also been futile. It is worth mentioning that as envisaged in the agreement notice, was issued through Sri Jamu of RJ Enterprise through my legal counsel to settle the matter through it. However, no response could be received. So legal notice was also issued. I have been trying to approach Sri Ojem Jamo of RJ Enterprise for the last 9 years, but he is untraceable. As such, the case, there is no scope for arbitration. So under the agreement, there is an arbitration clause also. And we are convinced that this is a clear case of fraud, cheating, and other criminal act. That Sri Ojen Jamo is intentionally with fraudulent mind, ignoring me to return my investment along with profit and loss sharing of 33.33% of contract work, which is amounting to cheating and fraud towards me. Therefore, I earnestly request your kind authority to look into the matter seriously and register a criminal case against Sri Ojem Jamo, proprietor of RJ Enterprise, for cheating me, and to take appropriate action against the above name accused Sri Ojem Jamo, and for which act of kindness I shall remain grateful. So this is the complaint. I'm doing a partnership business. After receiving 2 running bills, I have not given him his share. So whether this will amount to cheating, the law is very well defined.
Breach of contract.
Breach of contract. And at best, he can file a civil suit to recover the
Yes.
money.
What is your submission?
State what all I can do is I accept notice.
I was
But there
already
is a private
arrested.
party involved.
I was released on bail. I was arrested. I have stayed for about 2 months in the jail on the basis of this FIR.
You are on bail.
Yes, and my wife was called when I was in jail, and an agreement was signed by them forcibly. I'll come to those stays later on.
Will issue notice.
Yes, Lordship, and maybe please to stay the ongoing proceedings on the basis of this FIR.
Heard Mr. D. Saikia, London, senior counsel assisted by Mr.
B. Gogoi.
B. Gogoi, London counsel for the petitioner. This application under section 528 of BNSS also heard Miss, what is your name? AIR, London public prosecutor. Additional senior government advocate, Arunachal Pradesh.
Nagaland.
Nagaland. This application under section 528 of BNSS has been filed by the petitioner, Mr. Ojen Jamo. Ojen Jamo, praying for quashing of the proceedings of East PS case number 106/2025 under section 318 within bracket 3/316 within bracket 2 of BNS presently pending before the East Police Station, Dimapur, Nagaland. Learned counsel for the petitioner, learned senior counsel for the petitioner has submitted that the respondent number 2 had lodged a complaint against the petitioner before the officer in charge of East Police Station, Dimapur, Nagaland, mainly alleging that the respondent number 2, mainly alleging that the petitioner has not complied with the terms of agreement dated 21/10/2015 and has not paid back the invested money to the respondent number 2, neither he has paid any share of profit. Learned senior counsel for the petitioner submits that on bare perusal of the FIR, it would reveal that the accusation made against the petitioners are predominantly of a civil nature, and the allegation is mainly regarding breach of contract only, and no ingredients of offense under section
316 and 318.
318 and 316 of BNS has been made out. Issue notice to the respondents. Since Miss Iyer has, learned senior government advocate, has received the notice on behalf of the respondent number 1, no formal notice need to be issued. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 6th of November. In the meanwhile, considering the fact that prima facie on bare perusal of the FIR, it appears that the allegations leveled against the petitioner is mainly in respect of breach of agreement and is predominantly of civil nature. Further proceedings of East PS case number 106/2025 is hereby stayed till next returnable date.
Highly
Yes,
obliged.
Lord.
16.
Let's say petitioner and respondent number 2 got married on 24/4/2022. And thereafter, let's say they lived for 5 months at Bengaluru. And thereafter she came back. And she has filed an FIR before the officer in charge of All-Women Police Station in 2024, page 26. Can you see page 26?
Yes.
Let's see, they got married, solemnized on 22/4/2022 at Jonaki Resort at Jorhat. Let's see, got it?
Yes.
Let's see, thereafter, she has filed this FIR before the officer in charge of All-Women Police Station, Panbajar. Thereafter, Lordship, the page 29, Lordship, again, page 29, para 2, Lordship.
Lordship got it. Page 29.
Yes.
On 25th September 2022, after appeal in September, I finally reached Guwahati from Bengaluru and finally putting my life without harm and safety. Since then, I have been residing with my parent house at Guwahati. So within 2022, she came back. In 24, she has after 2 years, she has had an affair before the Olomouc police station, and thereafter petitioner has been called by the officer in charge to appear before the IO.
Which affair? This one?
This affair. On page 31. Page 31, petitioner has appeared before the IO about Olomouc police station, page 19 to 2021. After discussion, he has withdrawn the case. This is to a letter of the officer in charge. This is to inform that there will be a meeting held today on 19/2002 regarding the affair against my husband Raman Kumar Chaudhary for domestic violence and Olomouc police station. Both parties, although he and father in front of OC Twinkle Goswami, attended this meeting at her chamber. After discussion, we came to a conclusion for mutual divorce at certain terms and conditions. Hence, the affair for domestic violence is withheld for the time being. This is the signature of the originally that page 32. Page 32 is the original. Lordship got it?
Yes.
Lordship, thereafter, page 33 is a mutual letter by both the parties. Page 32. On 19 to 2024, Sweta Chaudhary, along with Raman Chaudhary, second party, arrived at a PS. Accordingly, we have decided amicably settle the matter regarding our differences. We will move before the Honorable Court. This is petition number 1, Raman Chaudhary and the wife. Originally, that page 34. Lordship got it?
Yes.
Hereafter, Lordship, petitioner has received a notice from the family court, page 35. She has already filed a case for divorce.
Yes.
And petitioner was directed to appear on 28th February 2024. On 35th 2024, petitioner was directed to appear. Hereafter, she has filed another criminal case. Lordship will find at page 65. Another case under Domestic Violence Act before the family court, before the CGM Kamrup. Lordship got it, page 65. Earlier case under domestic violence has been withdrawn with consent.
No, earlier the FIR.
FIR has been withdrawn on mutual discussion.
Okay.
Thereafter, she has filed this complaint before the CGM in 2024. Petitioner has received the notice. Lordship will find page 66 in the petition under section 12 for protection of Domestic Violence Act, page 66.
Yes.
Hereafter, Lordship will find another case has been filed, page 85. Under section 406. Page 85. Lordship got it?
Yes.
Another case has been filed under section 406 of the Criminal Procedure Code against the petitioner, and petition is at page 87. Hereafter, she filed another case, page 88, under 498A. Page 88. That is also 24. GR case number 140 of 2020. CR case number 140 of 2024. Same fact, same thing. And during taking cognizance, the Honorable Court took a report from the police officer of Olomouc Police Station, page 101.
Now, which case which order?
Regarding domestic violence case. Page 101. From the officer in charge of Olomouc Police Station, this report has been sought by the CGM. It is with reference to the subject, I have the honor to inform you that on 13 to 2024, means Sweta Sajani and Iman Gulagat written complaint Olomouc Police Station against husband and father-in-laws Iman. During inquiry, counseling session was done by the OC Twinkle Goswami. After counseling, both the parties agreed to proceed to the Honorable Court as a matter has been amicably settled between the parties and informant admitted written petition. OC Olomouc Police Station, they will proceed to the court for mutual divorce.
at certain terms and conditions, hence he withdraw the affair for domestic violence. This is the report by the officer in charge of Parliament.
That case was under 498A.
Lordship, all these cases have been stayed by this honorable court, page 103. Because multiple cases has been filed, only because Lordship, she is a doctor. She is earning 90,000 rupees per month as salary from the Lordship Marwari Maternity Hospital. And she is filing different cases only for extract money from the petitioner. This case has been stayed, page 103 is the order.
This 498A case.
Lordship. Now, Lordship, 406, page 104, another complaint in 24. Same facts, same things. And that is also stayed by this honorable court.
Page
Because
number,
multiple cases have been. Page 104 is the complaint petition under section 406/34. That has been stayed by page 119. That multiple cases has been filed after separating for last 2 years. In 2024, all these cases has been filed under different sections.
now which case you are challenging now?
Challenging the domestic violence case.
Where is the order?
Lordship will find the complaint petition at page 66. And page 65 is the notice issuing the appearance. Because Lordship is aware that multiple cases for the same facts and same allegation, all these cases has been filed to harass the petitioner, to drag the petitioner from Bangalore. And Honorable Supreme Court has categorically stated that multiple cases to spite a person is liable to strike down.
When is the next date fixed?
Next day is 8 of October.
We'll issue notice.
And further proceedings to be stayed in the meantime. Lordship. Otherwise, Lordship, petitioner has been dragged. All these cases have been stayed by this honorable court.
But this is not a criminal case.
This domestic violence case, Lordship, criminal case.
There are no penal consequences.
Because penal section, that is also domestic violence is a criminal case, Lordship.
Is there any penal section in domestic violence?
Because
You have to
Lordship,
give share household or.
No. There is no question of share. At his admitted position, she is staying at
No, but
Guwahati. She is staying at Guwahati. And
other two cases where
criminal case,
criminal cases having
Criminal cases.
penal consequences.
Lordship. But petitioner has been dragged unnecessarily in 3 different cases, showing different cause of action, not for the same cause of action, they have filed 3 different cases at Guwahati. So all these cases are to be.
No,
Lordship,
therefore, we are issuing notice. Let her
Lordship, I
appear.
understand, Lordship. Supreme Court has categorically stated Lordship will face Supreme Court judgment on this point that multiple cases has been filed. Permitting the filing of multiple cases should be a abuse of process of the court. I am giving the judgment, Lordship.
Heard Mr. S.K. Goswami. Learned,
Lordship has already stated the case against the parents.
learned,
But page 83.
okay, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Shri Raman Chaudhary, praying for quashing of the proceedings of Miss Divi case number 30/2024,
She is demanding 1 crore rupees.
2024, pending before the Court of London, Judicial Magistrate First Class, Kamrup Metro, Guwahati. The said DV case has been filed by the respondent number 2. She is still your wife or
Already divorce case is pending, but still not divorce is continued.
who is the wife of the present petitioner? Learned counsel for the petitioner submits that prior to filing of this case, the petitioner, the respondent number 2 had filed had filed several cases, namely case under section 498A IPC, as well as separate case under section 406 IPC, a divorce case also, he submits that the other criminal cases have been stayed by a coordinate bench of this court. The learned counsel for the petitioner further submits that initially the respondent number 2 had lodged an FIR before the all-women police station. Where is the FIR?
Lordship will find at
All-women police station
page 26.
alleging domestic violence against the present petitioner. When it was filed?
It was filed on date 13/2/2024.
Oh, on 13/2/2024. 13/2/2024.
After leaving for 2022.
Stop.
She has left the company in 2022.
Learned counsel for the petitioner submits that the petitioner and the respondent number 2 had parted their company in the year 2022.
25th September 2022.
Correct.
It is one.
Within bracket, in 2022. Stop. He further submits that the said case against domestic violence was withdrawn by the respondent number 2. The said FIR was withdrawn by the respondent number 2 after arrival of mutual settlement between the parties that they shall file divorce case. However, however, though a divorce case has been filed, who has filed the divorce case?
Wife.
By the respondent. She's filing multiple other cases only with a view to harass the petitioner. The other criminal cases, as stated herein before, have already been stayed by the coordinate bench of this court.
And this court also stayed the against the father-in-law and mother-in-law, page 83.
Okay. It is further submitted that it is further submitted by learned counsel for the petitioner that even the father and mother, the petitioner, the respondent number 2, even lodged case against the father and mother of the present petitioner. However, where is the stay order?
Page 83.
However, the said case was also
Stayed by your lordship
stayed by this court
on 24/6/2024.
by order dated 24/6/2024, passed in criminal petition number 699/2024. Stop. Issue notice to the respondent number 2 by registered post with AD as well as by usual mode. The petitioner shall take steps for issuance of notice within 7 days from the date of this order, returnable after 4 weeks. 4 weeks. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, further proceedings of DV case number
Page 65, 20 of
30
24.
30
30 of 24.
30 of 2024, pending before the Court of Learned Judicial Magistrate First Class Kamrup Metro, Guwahati, shall remain stayed till next returnable day. List accordingly.
Obliged, highly obliged. Lordship record missed DV case.
Miss TV case number 30.
Obliged.
May please your lordship. The petitioner has. May please your lordship. The petitioner has filed its revision petition.
Yes,
The petitioner has filed its revision petition against the order of the learned appellate court. Wherein the learned appellate court modified the order of the learned trial court to the extent of imprisonment to 1 month, 1 month and 3 months respectively, lordship. Relevant part of the impugn order is at page lordship 63.
yes,
Page 63, lordship, second paragraph, lordship. Resultantly, the appellate convict Sri Monty Gogoi Eli Simanto shall suffer simple imprisonment for 1 month for offense under section 448 IPC, simple imprisonment for 1 month for offense under section 506 IPC, and simple imprisonment for 3 months and fine of rupees 30,000. 3,000 in default, further simple imprisonment for 10 days for offense under section 385 IPC, lordship. He is on previous bail, lordship. At this stage, notice may go, lordship.
heard. Mr. P. Bordole, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 438/442 of BNSS has been filed by the petitioner, namely Monty Gogoi alias Simanto, impugning the judgment and order dated 16/8/2025 passed by learned additional session judge Golakar in criminal appeal number 24/2019, whereby the sentence imposed on the petitioner by the judgment and order dated 25/2019 by the learned judicial magistrate first class Dhan Siri Porupothar in GR case number 153/2018 was modified by sentencing the petitioner to undergo simple imprisonment for 1 month under section 448 of Indian Penal Code, and also sentencing him to undergo simple imprisonment for 1 month under section 506 of IPC, as well as sentencing him to period of 3 months, sentencing him to simple imprisonment for 3 months under section, and to pay a fine of rupees 3,000, and in default of payment of fine to undergo simple imprisonment for 10 months, 10 days under section 385 of APC. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the records of the trial court as well as appellate court be called for from the respective courts. Let this matter be listed. You are on interim bail.
Lordship, till then the suspension may be stayed, lordship.
Let this matter be listed after 4 weeks. In the meanwhile, considering the fact that the petitioner has been sentenced to a short-term period of 3 months only, the execution of sentence imposed on the petitioner by the impugned judgment shall remain suspended till the next returnable date.
Lordship.
The petitioner is also allowed to remain on previous bail granted to him by which court?
By the learned appellate court, Lordship.
By the learned additional session judge Golakar till further order,
Lordship.
list accordingly.
Lordship. Oblige, your Lordship.
May it please your lordship. Lordship, I am aggrieved by an order passed by District Commissioner Khemaji, whereby my lord, in a dispute between two parties, he has ordered demolition of my house. Lordship will find that order at Annexure 2, page 10. My lord, there are 3-4 orders. I will read the entire order, my lord. Lordship, may kindly come to order dated 26th of August 2025. Has your lordship got in?
Page number?
Page number 10.
Yes.
I am reading, my lord. Order dated 26/8/2025.
These orders are passed in which proceeding?
My lord, in a proceeding case number, lordship will find that is a proceeding DCL 3 of 2025-26. My lord, this is a dispute wherein the respondent number 2 wherein has alleged that I have encroached into his boundary and there is a dispute. I'll read, my lord, that order 26th of August.
Page number?
10.
Okay.
A petition.
What this DCL stands for?
I am not aware, my lord. First time I have also got this, my lord.
How will you assist this court?
No, my lord. That is why I also asked myself, my lord, whether that is why I will read order dated 26/8/2025, my lord. Petition received from Sri Babul Kaur, son of so-and-so, Post Office Silapathar, Dhemaji,
No,
regarding a
why have
quantum
you
of.
preferred a criminal revision petition?
Yes, my lord. Let me kindly read this order, my lord.
Okay.
A quantum of government khas land measuring 3 bigha 1 katha of Dag number 113 of Likabali Alika Cow under Sisiborgao Revenue Circle, which is referred to be as the first party herein. The first party has stated that land quantum mentioned above has been occupied by them since 1984. In the meantime, first party has complained of illegal encroachment and sale of the land by Sri Jitu Mipun. He is the petitioner here, son of so-and-so, which is referred as the second party. The petitioner stated that out of 3 bigha 1 katha of land was under their occupation and dispute has arisen on fencing the boundary of 4 katha 8 lesas of land. Issue notice to both the parties to appear before this district commissioner.
Under what,
Khemaji at
under what provision
what
these?
provision that has not been mentioned, but from the complaint itself, it is seen it has to be a proceeding either under 126 BNSS or it has to be 164 BNSS. Lordship will see the notice at page 9 that was issued. I have translated copy at page 9, Annexure 1. This is the notice issued upon us by the district commissioner. Well, there was a dispute as alleged regarding the boundary. Thereafter, Lordship, kindly see order dated 8/9/2025.
No, why this court exercising criminal jurisdiction would, now this roster is criminal roster. Why it should access?
To my understanding, my lord, when there has been an allegation of this nature and proceeding has been taken up between the parties, this is a proceeding either under 126 BNSS or 164 of BNSS.
But there is no mention about.
No mention, but he has ordered proceeded under that. He has called us for hearing. We have submitted land documents. He has called for circle officer's report. Kindly see order dated 8/9/2025 at page 10 itself. May I read it, my lord? Both the parties were present. The second party represented by learned advocate submitted it is manual. It should be annual Patta 7, Dag number 146 of Likabali Alika NC village. The annual Jamabandi registered in the name of Sri Jitu Mipun. Gau Pradhan of Likabali Alika NC village submitted petition regarding the disputed land, stating that second party sold the land measuring 3 bigha 1 katha to various parties, namely Sri so-and-so. He further stated that he stopped the second party from constructing the bamboo fence
The Gao Pradhan further stated that he was called by Sri Jugal Sonwal, officer in charge of Likavali outpost of Silapathar police station, and directed him to stay out of the dispute. The LRA of the subordinate of the
No,
law.
though it appears that writ petition may be maintainable. How and why this court will exercise jurisdiction under 442 and
My lord,
438?
impugned order says, impugned order, which is at, my lord, on the next page at page 11. He has, my lord, at page 11, 29/2025 is the impugned order.
Yes.
My lord, both the parties were present. Second party was represented by learned advocate. The report of circle officers CC Borga Revenue Circle regarding the validity of the land document submitted by second party was seen, and the statement of LRA and Gao Pradhan were seen regarding construction of permanent structure by second party within 1 month. It was observed from the record that the land in dispute is not cadastral land, cadastral village, and no map of the village is available as ascertaining the position of DUG numbers. Also, as per the report of circle officer, records from old register of the encroachment where it is seen that 3 Katha land of the enclosed in the name of first party and 3 Katha land is recorded as enclosure in the name of second party. Hence, under such circumstance, land record submitted by the second party has no legs to stand. Second party hereby instructed to make the land measuring 4 Katha 8 lesas of Likavali Alika village under Sasivarwa Revenue Circle encroachment free within 7 days. From the date of this order, circle officer CC Borga is further instructed to ensure demolition of the permanent structure under prevalent laws, and he is further instructed to maintain law and order and to prevent so and so and so. Well, this order in a case between two parties, my lord, when there has been an allegation of encroachment into his land, raising boundary fencing, my lord, the district commissioner has no authority to pass such an order, my lord. And apparently the proceeding which the order has been passed.
No, that I understand.
My lord, I was also confused, my lord, and I thought
you have
it is the case, my lord. So it has to be under CRPC and a revision lies, my lord.
No, why you reached that conclusion?
My lord, because
Why have you not approached the
allegations
writ? You should have approached the writ court. Because for invoking the jurisdiction of this court, sitting on a criminal roster, you have to first satisfy.
My lord, that's why, my lord, this is a case he issued notice to us between two private parties, and my lord, adjacent land he is occupying, he is not disturbed, but I am asked to vacate.
This appears to be a dispute of civil nature.
No, my lord, under 145 earlier CRPC, my lord, attachment
But
under 107, my lord, bond will be executed, and then we will approach the appropriate civil court, my lord. That's the proceeding, my lord. My lord, 126 BNSS and 164 are just a replica of earlier 107 and 145 of CRPC.
But there is no indication that this case is registered under those provisions.
They have not mentioned under what provision, my lord.
And what
Not
this,
mentioned, but the nature of the order passed and the allegations raised, it has to be under 107 or 126 and 164 BNSS.
what this DCL means?
That also I don't know, my lord. Maybe they have nomenclature. Deputy Commissioner, District Commissioners, land, something maybe, my lord.
Yes, Mr. Parash.
But revision also I am not understanding. Otherwise, the two proceeding is 126 and 164, earlier 107, 145 maybe. But it is not mentioned anywhere. And revision only a single order, no appeal, no. Directly.
Order was passed on 20th of September.
No, why you have assumed this to be?
Because, my lord, the allegation and the proceeding he conducted, my lord, the nature of the proceeding he got, it has to be a proceeding, it is in the nature of, my lord, 126 or 164 of BNSS. These two only. There are no other provisions, to my knowledge, my lord, under BNSS. Executive magistrate can go. District Commissioner is executive magistrate, acting as executive magistrate. He is dispensing a quasi-judicial jurisdiction here in my lord. To maintain peace and order and this prohibitory order, he can pass under 164 BNSS. And that is, my lord, amenable to criminal jurisdiction, my lord. That can be put on challenge by revision, my lord.
Heard Mr. P. Hajurika.
My lord, I am T.R. Sharma, my lord.
Heard Mr. P.R. Sharma, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. this application under section 442/438 of BNSS has been filed by the petitioner Shri Jitu Mipul, impugning the order dated 29/2025, passed in DCL number 3/2025 -26 by learned District Commissioner Dhemaji, whereby the petitioner was directed to vacate his lands within 7 days, and the circle officer CC Borgaon was also directed to demolish the permanent structures standing on the said land. Learned counsel for the petitioner has submitted that though there is no mention in the impugned order as to under what provision of law the District Commissioner Dhemaji has exercised his jurisdiction while passing the impugned order. However, even if it is assumed that the petitioner that the impugned order was passed under section
126 BNSS or under section 164 of BNSS.
126 is
Maintaining law and order, asking the parties to execute bond.
107.
107 earlier CRPs.
126 and
164, that is 145 equivalent CRPs.
last line ki likh le. Even if it is assumed that the learned District Commissioner Dhemaji has exercised the jurisdiction under section 126 BNS or section 164 BNSS. Still, considering the fact that the dispute is between private parties regarding the land, the learned Deputy Commissioner Dhemaji has exceeded his jurisdiction while directing the petitioner to vacate the said land and also directing the circle officer CC Borgaon to demolish the structure standing there on stuff. A question was raised, a question was posed by this court to the learned counsel for the petitioner as to when there is no indication in the impugned order as to under what provision of law the said order has been passed, how this criminal revision is maintainable. How much time is granted for demolition?
7 days, my lord.
7 days.
Today is 26, tomorrow 27. 7
You
days.
answer this query.
My lord,
We are giving you interim protection.
yes, my lord.
And
And
you
therefore-
also answer what is the full form of this DCL.
Definitely, my lord.
learned counsel for the petitioner submits that he may be granted some time to respond to the query. However, he prays for an interim protection as by the impugn order passed on 29/2025. The District Commissioner Dhemaji had granted 7 days time for execution of the impugn order. Stop. The prayer is allowed. Since learned additional public prosecutor has appeared, no formal notice need to be issued to respondent number 2.
Who is the
Respondent
private
number 1. Issue notice to the respondent number 2, keeping open the question of maintainability of this revision petition. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 3rd of November. In the meanwhile, considering the urgency of the matter, the impugn order dated 29/2025 passed in DCL number 3/2025-2026 is hereby stayed till next returnable date.
I'm
Please
obliged.
accordingly.
Scan copy of the record may also be called for.
Yes. Let the scan cover. The question of maintainability is
Is there, my lord. That is why I'm praying for scan copy, my lord.
let the scan copy of the case record of the DCL
3/2025-26.
3/2025-26 we call from the office of the Deputy Commissioner Dhemaji,
District Commission.
the District Commissioner Dhemaji.
I'm deeply obliged.
Registry to issue requisition, registry to take steps for requisitioning the scan copies. Let this case be listed on 3rd of November.
Obliged.
Item 52.
May please. This is a revision petition, your lordship, arising out of the NIAC matter, where the petitioner has been convicted for 6 months and pay a fine of 5 lakhs. But the matter has been amicably settled between both the parties. The other side has also appeared. They have received the amount of complete of 5 lakhs rupees from the family.
You have filed any you file it in writing or composition?
Yes.
That if you intend to compound the offense, no oral submission. You file in writing that you have settled the matter. Till then we will suspend the,
There is a your lordship, he is behind the bar, he may be allowed to go and give.
we'll allow that. Heard Mr.
Yes, sir.
S. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, as well as Miss, what is your name? A. Hussain, learned counsel for respondent number 1. K. Parashar for respondent number 2. Okay. this application under section 438 of 438/442 of BNSS has been filed by the petitioner, namely Surajit Day,
No, Lordship, Jeet Jyoti Laskar.
Jeet Jyoti Laskar, impugning the judgment and order dated 31/7/2025, passed by learned Sessions Judge number 2, Nagaon, in criminal appeal number 7 within bracket N/2024, whereby the appeal preferred by the present petitioner, impugning the judgment and order dated 26/12/2023, passed by learned Additional Chief Judicial Magistrate, Nagaon, in NI case number 7/2016, was dismissed by the trial court. By the aforesaid judgment, had convicted the petitioner under section 138 of NI Act, 1881, and had also sentenced him to undergo simple imprisonment for 6 months and to pay a fine of rupees 5 lakhs to the respondent number 1 as compensation. Stop. Learned counsel for the petitioner has submitted that the parties to this case have amicably settled the matter and the compensation amount has already been paid by the petitioner to the respondent number 1. Stop. Learned counsel for respondent number 1 submits that the respondent number 1 has received the compensation amount from the petitioner, and he is intending to compound this case against the petitioner. Learned counsel for the respondent number 1 further submits that some time may be granted to bring on record in writing the fact of amicable settlement reached between the parties. The prayer is allowed. Let this matter be listed again on when? Again after 4 weeks. In the meanwhile, considering the facts and circumstances of this case, the execution of sentence imposed on the petitioner by way of the impugned judgment is stayed till the next date. The petitioner is also allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Additional Chief Judicial Magistrate, Nagaon, in NI case number 7/2016, until further orders, list accordingly.
Yeah, it becomes important.
In view of the orders passed in the criminal revision petition, this interlocutory application has become infructuous and accordingly disposed.
What's up?
Your eye has not yet.
I has not yet come, my lord. Let it come.
After
Yeah,
after
after
lunch.
2, my lord, after lunch. I go. After lunch.
Item 54.
May I please the lordship? So in this case, the petitioner is aggrieved by a judgment and order of conviction dated 18/8/2025 in an NIAC proceeding, my lord. And the appellate court also affirmed the judgment and order passed by the London trial court. In page number 2, in cause title, lordship will find the sentence 10 lakh 1 year imprisonment and to pay a fine of rupees 10 lakhs in default, 4 months of
What is your ground?
lordship. Here in this case, the trial court as well as the appellate court failed to consider one thing, the source of income, first of all. And secondly, he has not even recognized at the date when he paid the amount to the present petitioner.
Heard Mr. P.P. Borthakur, learned counsel for the petitioner. State is a party.
Yes.
Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438/442 of BNSS has been filed by the petitioner, namely Prabhas Patwari, impugning the order dated 18/8/2025 passed by learned additional session judge number 5, Kamrup Metro at Guwahati in criminal appeal number 55/2021. Whereby the order dated 30/3/2021 passed by learned Chief Judicial Magistrate Kamrup Metro in CR case number 2390/2012 was upheld. By the aforesaid judgment, the trial court had convicted the petitioner under section 138 of the Negotiable Instrument Act 1881 and sentenced him to undergo imprisonment for 1 year and to pay a fine of rupees 10 lakhs, and in default of payment of fine to undergo simple imprisonment for 4 months. I have considered the grounds pleaded by the petitioner in this revision petition, impugning the judgment of the appellate court. Issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Stop. In the meanwhile, you are behind the bars or on bail?
No, I'm on bail.
In the meanwhile, the execution of the sentence imposed on the petitioner by the impugned judgment shall remain stayed till next returnable date. The petitioner is also allowed to remain on the previous bail granted to him by the appellate court till next returnable date. Stop. Least accordingly. In view of the orders passed in the criminal revision petition 413/2025, this interlocutory application has become infructuous and accordingly disposed.
Alright.
33 Lordship. In this case, Lordship, they file an objection, but same was not taken in the file. So, Lordship, kindly call for the item number 33, Lordship.
Item number 1.
For reasons mentioned in the judgment, this regular second appeal is dismissed.
Item 46 from supplementary list.
For reasons mentioned in the judgment, the criminal appeal is dismissed.
Item 55.
Yes.
So he was not found.
Yes. Yes.
Next order of looking like these are three of 5,000. Again, someone is to be assumed does not start business. The multi-family very traffic is very important. Variable warrant of 50 person start issuing
Okay, what relief you are seeking? Yes, Mr. Sharma, let him appear. Heard Mr. A.I. Uddin, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Soriful Islam, who is aggrieved with the order dated 27/5/2025, by which the Court of Learned Chief Judicial Magistrate Lakhimpur had issued non-bailable warrant of arrest against the present petitioner. Learned counsel for the petitioner has submitted that the charge sheet has been laid against the present petitioner in PRC case number 1605/2022 under section 376 of the Indian Penal Code. And the trial court, though issued summons at the first instance, however, without ascertaining the due service of summons, it issued bailable warrant of arrest and stop. He further submits that in the report of the bailable warrant of arrest issued against the petitioner clearly shows that the petitioner was not found in his residence. However, in spite of that, the non-bailable warrant of arrest were issued against him. When is the next date fixed? Date. Learned counsel for the petitioner has submitted that the next date of the PRC case number 1605/2022 is fixed on 14/11/2025, and the petitioner is willing to appear before the said court and cooperate in the trial. However, he seeks some protection as pending non-bailable warrant of arrest has been issued against him. Stop. Considering the submissions made by learned counsel for the petitioner, this criminal petition is disposed of with a direction to the petitioner to appear before the Court of Learned Chief Judicial Magistrate, Lakhimpur, North Lakhimpur, in PRC case number 1605/2022 on 14/11/2025. That is the next date fixed for appearance of the petitioner in the said case. Stop. To facilitate his appearance before the said court, the operation of non-bailable warrant of arrest issued against him shall remain suspended till that date. This criminal petition is accordingly disposed of.
Item 56.
After something.
57. By the government team and both fictional. One is the victim, four is the. The other the one is five is five.
Yes. 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 They are married to each other. Okay. Yes. Heard Mr. A.I. Uddin, learned counsel for the petitioner. This application under section 528 of BNSS 2023 has been filed jointly by petitioner number 1, and jointly by Muhammad Sabikun Nehar, Rizabur Rahman, number 2 Rizabur Rahman, and Muhammad Isab Ali and Muhammad Nurul Haq, praying for quashing of the proceedings of special POCSO case number 115/2022 arising out of Lalu PS case number 296/2021 under section 363/294/506/34 of the Indian Penal Code. Stop. Learned counsel for the petitioner has submitted that though in the FIR which was lodged in the year 2021 against the petitioner, it was stated that the victim girl was of 16 years of age. However, her actual age at that point of time was 19 years, 6 months. In support of his submission, learned counsel for the petitioners has produced the birth certificate of the victim girl. Stop. He further submits that the victim girl, being major at the date of the alleged incident, had eloped with the respondent number 2, and later on they married each other. Now they are passing their life as happily married couple. And they also had a child out of their wedlock, who is presently of what age? Who is presently 3 years of age. Stop. Learned counsel for the petitioner submits that this application has also been filed jointly by the victim girl and the accused persons. And there is, and in view of the facts and circumstances of this case, there is unlikelihood of whether records would be necessary or there is unlikelihood of, no, let us verify. Unlikelihood of the aforesaid criminal proceeding ending in conviction, and he submits that it would be futile exercise to waste precious judicial time in view of the fact that the victim and accused are now related to each other as husband and wife, and they have a child also. Stop. Considering the submissions made by learned counsel for the petitioner, this court intends to peruse the records of the case. Hence, let the records of special POXO case number, scan copy of the records of special POXO case number 115/2022, along with the connected case diary, be called for from the trial court. However, considering the facts and circumstances of this case, as well as the submissions made by learned counsel for the petitioners as discussed in the foregoing paragraph, further proceedings of special POXO case number 115/2022 pending before the court of learned special judge within bracket POXO Lakhimpur shall be stayed until further orders. List this case again on 10th of November.
Item 58.
What is the offense? Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Golab Khan, impugning the order dated 18/9/2025, passed by learned Additional Chief Judicial Magistrate Gwalpara in connection with Lakhimpur PS case number 74/2025, whereby the prayer for Jimma of the seized vehicle was rejected by the said court. Let a report be called for from the investigating officer of the Lakhimpur PS case number 74/2025 as to whether the seized vehicle is still required for the purpose of investigation and whether the Jimma of the said vehicle may be granted to the petitioner or not. Let this case be listed again on 22nd October for report.
Item 59.
Which order has been challenged? Where is the impugned order? Annexure? Page number? What is the order? You have not preferred any appeal, but appeal lies. Yes. This petition is not maintainable. There is a bar. When there is a specific provision for preferring an appeal against the order, why this court should invoke its inherent power? You can raise everything before the appellate court. Still you can go on appeal. Should I dismiss it? I mean, this is a case for dismissal, or you may withdraw it. Heard Mr. A.K. Ahmed, learned counsel for the petitioner. D.V. Aktioxen, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner impugning the final order dated 2/6/2025 passed by the Court of Learned. Which court has passed this order? Judicial Magistrate First Class Thubri in CR within bracket DV case number 260/2023, whereby the petitioner was directed what was the direction? Petitioner was directed pay a maintenance allowance of rupees 5,000 to the respondent, as well as protection order was also granted in favor of the respondent by the trial court on a specific query posed by the petitioner as to when the statute provides for appeal against the said order under section 29 of the DB Act, whether this application under section 528 is maintainable. Learned counsel for the petition, you have any authority? Learned counsel for the petitioner submits that this application is maintainable. Stop. It is a settled legal proposition that inherent powers of the court, of this court under section 528 may not be exercised if there is an alternative recourse available to the petitioner. In the instant case, the petitioner has approached this court without availing the facility of filing the appeal under section 29 provided by the statute within bracket. Protection of DB Act 9 Protection of Women from Domestic Violence Act, 2005. This court is of considered opinion that when there is a statutory remedy available to the petitioner in the form of an appeal, it may not be proper to invoke this court's inherent powers under section 528 of BNSS. Therefore, this criminal petition is rejected, dismissed.
Hearing be item 24.
How many days? What is the offense? POXO.
Status report was called for, that has been received. It is in the second file, Lordship.
What is the status?
Status report, Lordship, no PW has been examined so far, Lordship. And Lordship, the court was vacant, Lordship, but now Lordship, new additional district and session judge has joined office on 6/9/25.
What is the accusation?
6 of POXO and 362.
Let the victim be examined at least. Victim, you have anything to say? What settlement?
Lordship, one more thing, Lordship, the last date was 25/9/25, so fixed for evidence. So that is not clear, Lordship, whether.
Who are you, father or mother? Mother. Okay. Heard Miss T. Begum, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned. Yes, Mr. Sharma.
Lordship, I pray would be, Lordship, at least the victim should be examined.
What is your age? And what is the age of the victim?
Her date of birth was 10/12/2007. She was around-
Also at Mr. B. Sharma, learned additional public prosecutor, as well as Mr. What is your name? A. Mubarak, appearing for respondent number 2. Learned counsel for the petitioner has submitted that on the basis of an FIR lodged by the respondent number 2 against the petitioner, the Tamulpur Police Station case number 76/2024 was registered under section 363/365/376 within bracket 2 within bracket small n /506 of IPC, read with section 6 of the POCSO Act. And after completion of the investigation, charge sheet was laid against the present petitioner under the aforesaid provision of law. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 275 days. And the trial is yet to commence. She submits that the petitioner is ready to abide by any condition imposed on him while granting bail to him, and he shall cooperate in the trial. On the other hand, an additional public prosecutor submits that till date, the examination of prosecution witnesses have not yet been started. He submits that before considering the prayer for bail of the petitioner, at least the victim girl may be examined. On the other hand, learned counsel for respondent number 2 / informant has submitted that the informant, who is the mother of the victim girl who lost the FIR, does not have any objection if the petitioner is granted bail, as he also submits that the FIR was lodged due to some misunderstanding and the matter has been settled between the parties. So, I have considered the submissions made by learned counsel for both sides. Stop. Considering the fact that the petitioner has been detained behind the bars for last 275 days, also considering the submissions made by learned counsel for the informant / respondent number 2. This court is inclined to grant bail to the petitioner in this case. Accordingly, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge POCSO Baksa, with following conditions, trial conditions belong to. This bail application is accordingly disposed.
25 and 26.
May I please, your lordship? Your lordship, the matters may be adjourned for the day as it will be difficult for Mr. Kyal to appear today, your lordship.
None appears for the petitioners on call. Miss R. Hussain, learned counsel for NCB, prays for an adjournment. on the ground of personal difficulty of the conducting counsel for the NCB. Considering the submissions, the prayer is allowed. Let this matter be listed on 23rd of October.
And for item 61.
Yes. Who are you? You are the owner or
I am running the business.
you are the owner of the beauty parlor?
61 is the,
Okay.
61 is the running, she is running the beauty parlor lordship. 62 is the owner lordship. He allocated the parlor to the petitioner in item 61 to run the parlor. Oh, I'm sorry, lordship, 63, 63, yes. 62 is the three victim girls are there, lordship. Three statements are there.
One 143, one.
143.
What is your submission?
For the affair, there are three victims. There is the allegation specifically that my lord, that I engage those girls in the sport business my lord and running a my lord Texas. Whereas my lord, those girl my lord, those victim girl my lord, as mentioned in the affair my lord, they are, one is 25, another is 23, another is 25 years. They are free to move, that free. They are residing in a separate accommodation, my lord, their respective rented house, my lord. I never confined them, my lord, neither in my beauty parlor nor anywhere else, my lord. They were voluntarily working in my beauty parlor, my lord. And my lord, another thing is that, my lord, I being a lady, my lord, I have another beauty parlor also, and I am running another beauty. It is not possible for me, my lord, to constantly present in the said beauty parlor as a contributory, my lord. If, my lord, anything, my lord, done by those victim, my lord, that by their own wishes, my lord.
What is the date of your arrest?
10/9, though my lord, I was arrested on 9/8.
Accusation in this case is that on on 9/8/2025, one Korobi Soikia, SI of police, had lodged an FIR before the officer in charge of Dispur police station, inter alia alleging that on receipt of an information through reliable sources that a sex racket is being run in a beauty parlor located at Ganeshguri under the name and style Looks Parlor. A search operation a raid was conducted in the said beauty parlor, and during raid, the 3 numbers of victim girls were recovered, were rescued therefrom, and 3 accused persons, including the present petitioner, were arrested. Stop. Learned counsel for the petitioner submits that the petitioner has been languishing behind the bars since last 47 days. He also submits that the petitioner never forced the victim girls to indulge in immoral activities. He further submits that as all the victim girls are major and therefore they cannot be compelled to indulge in immoral activities. She also submits that a learned counsel for the petitioner also submits that the petitioner is a mother of 2 children and considering and in her absence, nobody is there to look after the children of the petitioner. Stop. He further submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Dispur PS case number 669/2025 and has submitted that the victim girl have implicated the petitioner in their statement made during the course of the investigation. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Stop. Though it appears that there are incriminating materials against the petitioner in the case diary, however, the investigation has fairly progressed. Stop. Moreover, considering the period of detention undergone by the petitioner within bracket 47 days, this court is of considered opinion that if the petitioner cooperates in the investigation, her further custodial detention may not be necessary for fair completion of the investigation of Dispur PS case number 669/2025. In view of the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned Chief Judicial Magistrate Kamrup with following conditions. Number 1 and number 2. Send back the case then. See? 62, who are you?
Doctor, I went for a haircut, your lordship. Whenever the police present over there, arrested me.
Same submission.
Submission of लिखिए बाकी के ताकि change. Learned counsel for the petitioner has submitted that since when you are behind the bar, same 47 days.
Same.
Submitted that the petitioner is in no way involved in the offense alleged in the FIR. He submits that he went to the saloon where raid was conducted for a haircut only, and the police finding him at the place, at the saloon, at the beauty parlor when the raid was conducted, picked him up. He further submits that the petitioner has been detained behind the bars for last 47 days, and considering the period of detention, he may be allowed to go on bail. Baki ek nisna tha ki 30,000. 63.
Okay. Is the owner lodge.
Learned counsel for the petitioner submits that the petitioner is the owner of the place where the aforesaid beauty parlor is being run by the accused number.
Okay, he is the owner of the spa lordship,
He is the owner.
Yes. He gave authorization to the item 61 to run the place. Otherwise, he is the owner.
He is the petitioner submits that the petitioner is the owner of the beauty parlor from where victim girls were recovered. He, however, submits that he is not involved in day-to-day affairs of the said beauty parlor, as he had authorized one Binita Das to run the said beauty parlor. He further submits that he is ready to cooperate in the investigation and prays for bail considering the period of detention undergone by him remaining same. 30,000 with funds.
Well, also we have received the report, Lordship. No case other than the present one is pending against the present.
Heard Mr. What is your name? J. M. Suleiman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the officer in charge of Badarpur police station has furnished the report as called for by this court by order dated 25/9/2025. He submits that apart from the Badarpur PS case number 149/2025, no other case is pending against the petitioner in the said police station. Stop. He has also produced a copy of the said report. Let the report be kept in the record after marking the same as X. Since the petitioner has already been granted protection in Badarpur PS case number 149/2025, the apprehension of getting arrested in some other case, apprehension of his getting arrested in some other case, is without any basis, and therefore this anticipatory bail application is dismissed.
Dear Lordship, the petitioner is an interim and CD has not been received, Lordship.
Heard Mr. S. Chauhan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 10th of November. The interim bail granted to petitioner earlier shall continue till next day.
Item 28. 28, Lordship, the petitioner has appeared, Lordship, and he has cooperated.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted, petitioner namely Joynal Abedin, was granted interim bail by this court on 26/5/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Learned additional public prosecutor has produced the case diary and has endorsed the submissions made by learned counsel for the petitioner. Stop. Since the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to the petitioner by order dated 26/5/2025 is hereby made absolute with condition number within bracket Roman 1 and within bracket Roman 2 attached to the said order shall remain intact. With above observation, this anticipatory bail application is disposed of.
He will appear as an on court for Lordship.
Condition is there.
Item 30. Third bail application.
Heard.
Here on page my lordship.
Where is the last rejection order?
Page 21. I have filed additional affidavit. Submitted to supported document.
What are the new grounds?
Made a report, my lordship, the internal politics finding. I have annexed the document. On document dated 28/7/2025, it is filed by the victim judge before the inspector of police.
What document?
Present to the inspector of police by stating that, can you read my?
What they have stated?
With due respect, we beg to state that we are students of LHO High School on 7/12/2024. We had submitted a complaint against our headmaster. Unfortunately, before fully understanding the contents of the complaint, we were compelled to put our signature. Third, it is in this matter, we had even signed before the honorable court and other places, but such complaint was made under the influence of various groups and organizations without properly understanding the consequences. We now realize that we have made a mistake against our headmaster, and we are deeply grateful and sorry for the same. Therefore, we must humbly pray before you not to take any action against our headmaster, the Anil Chandra Nath, and on the basis of the complaint which we had unknowingly signed. Hence, we request you to, that considering our future career, this complaint may kindly be ignored, and necessary steps may be taken to reinstate our master the school. My lordship, I have also annexed one document, that is the bail application, page 28, my lordship. It is the informant, my lordship, page 28. And type copy.
This is a POXO matter.
Mother.
Where is,
Yeah, amicus is there.
who is the amicus?
MK Brown is there, this coming.
Okay.
This case investigation is required, my lordship, to unearth, my lordship, because I am the victim here. Anticipatory bail, I'll provide with the investigation. And the police will be directed to investigate properly. I have been framed. I have annexed also another document, annexure 4 in page 25. This is the document, my lordship, resolution of dispute, my lordship, will be signed by the informant.
Where is your first rejection order? Is there?
That stand was taken by the petitioner in the first round of litigation also. After going to the case, it was rejected. That stand was there, in the page 23, may see, in the earlier petition, they have also taken the stand. No objection is there. But here, the informant, the victim girl, informant's daughter, her statement is there in 183 statement.
other six students, other six of the same school, from class 7 to class 9, all are from from the age of 13 years to 15, 16 years, my lord. All have said the same thing, my lord. Now, under some condition.
Public Prosecutor, as well as Ms. M.K. Brown, learned counsel for respondent number 2. This application under section 482 of BNSS has been filed by the petitioner, namely Anil Chandra Nath, praying for Anil Chandra Nath, apprehending his arrest in connection with Moregaon PS case number 352/2024 under section 75 within bracket 2/78 within bracket 2, read with section 10/12 of the POCSO Act 2012. The gist of accusation in this case is that quote paragraph number 3 from page 18. Quote para number 4 from page 18. This is for the third time the petitioner is approaching this court for seeking protection under section 482 of BNSS in connection with the aforesaid case. On earlier 2 occasions, his prayer for anticipatory bail was rejected after perusal of the case diary. This time, the petitioner has relied upon, has filed a letter by 10 numbers of students addressed to the Inspector of Schools, Moregaon District, wherein it has been mentioned that the signatories of the letters had on earlier occasion made statement against the petitioner without understanding the consequences. And stop. Learned counsel for the petitioner submits that the petitioner submits that the said students were pressurized by various organizations to depose against the petitioner. He further submits that in the meanwhile, the informant has also, where is the letter? Informant has also entered into compromise with the petitioner by executing a deed of resolution of dispute on 17th day of June 2025. Stop. Learned counsel for the petitioner has submitted that in view of the new materials produced by the petitioner, and in view of the fact that he is ready to cooperate in the investigation, he may be allowed to go on anticipatory bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner. on the ground that on earlier occasion also the petitioner was the petitioner took the plea that he has been falsely implicated, and after this court, after perusal of the case diary, had rejected the prayer on both on two earlier occasions. Stop. Learned amicus curiae for appearing for the respondent number 2, your submission similar or
Affidavit. The language in the last paragraph, Your Lordship.
page 30? 38. Yes.
Lordship, it says out of fear of our future life and career, Your Lordship. So it can be presupposed, Your Lordship, that they were pressurized into giving this application, Your Lordship.
Yes. Learned amicus curiae has submitted that, has made submission similar to that of learned additional public prosecutor. In addition to that, she has also submitted that the letter on which the petitioner is relying this time for seeking bail itself shows that the undertaking, the letter was written by the signatory students due to some kind of pressure, as they have, as it has been stated, that they are worried about their future career and life, and therefore they have prayed for ignoring the earlier complaint. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. The accusation against the petitioner is that being headmaster of a school, he had subjected not only the victim girl to sexual harassment, but also some other students, some other girl students also, who clearly implicated the petitioner of subjecting them to sexual harassment in the school. Stop. The letter submitted by some of these students of the school appears to be not free from any pressure, as the language itself indicates to that fact. This court is of considered opinion that in view of the sufficient incriminating materials against the petitioner in the case diary, as well as in view of the fact on earlier 2 occasions, the prayer for anticipatory bail was rejected after perusal of the case diary. This is not a fit case where benefit of a favorable order under section 482 of BNSS may be granted to the petitioner at this stage. The prayer for anticipatory bail is therefore rejected. Send back the case diary.
32.
41 কি হয়েছে? List this matter after puja vacation. None has appeared for the petitioner on call. Learned Mr. K.K. Parashar, learned additional public prosecutor. List this matter after puja vacation along with item number along with AB case number 1692/2025 on a date to be fixed by registry.
Item 43.
What?
Yes, I think one after another. only the harassment.
CD is there, Malad, he will be the informant party, Malad. I'll call,
Okay.
materials are there in that.
Yes.
Okay, FIR is that page 13, the vernacular is there.
Okay. Page number?
মোৰ স্বামীৰ ঘৰৰ পৰা
AM. What is your name? R.A. Ahmed, learned counsel appearing for the respondent number 2. This application under section 482 of BNSS has been filed by the petitioners, namely Abdul Razzaq Ali, alias Razzaq Ali, number 2, Saidul Islam, number 3, Abdul Malik Ali, number 4, Mukhtar Ali, number 5, Muskur Ali, number 6, Nasir Ali, alias Nasar Ali, who are apprehending their arrest in connection with what is the PS case number?
This is Mayong PS case number
PS
105
case number 105/2024.
2025.
2024 or 20?
Sorry, they have wrongly written. In our application, it is correctly written.
105/2024 under section 61 within bracket 2/65 within bracket 1/142 of BNS, read with section 6 of the POCSO Act. Stop. The gist of accusation in this case is that on 9/9/2024, the mother of the victim girl had lodged an FIR naming therein the present petitioners, inter alia, alleging that on 15/7/2024, the petitioner number 1 and 3, namely Razzaq Ali and Saidul Islam, forcefully abducted the minor daughter of the informant. Stop. Learned counsel for the petitioner has submitted that the petitioners are in no way involved in the offense alleged in this case. He further submits that in the meanwhile, the petitioner number 1, Razzaq Ali, has already been arrested and therefore this instant application under 482 PNSS as against him has become infructuous. He further submits that the other accused persons, no specific role has been ascribed to the other accused persons against the in commission of the alleged offense.
Abdul Malik, second half to Malik Kerala and came I think Malik and Abdul Malik. And that in the case of the 2 days Abdul Malik, second half to Malik.
Lordship, but in the bail objection, they have clearly stated that it
Saidul-
was by the Saidul.
Saidul,
Not, there is no whisper of any allegation against Abdul Malik. It is
we
the
will not
information
go by bail objection, we'll go by what is there in the case.
Yes. that Saidul can be granted, Lordship.
Stop. की लिखे ले last line तो ascribed AS ascribed against them in the FIR. Stop. He further submits that the petitioners are ready to cooperate in the investigation and their custodial interrogation may not be necessary in this for fair completion of the investigation. On the other hand, learned additional public prosecutor has submitted that has produced the case diary of Mayan PS case number 105/2024 and has submitted that though in the FIR accusation has been made mainly against Saidul Islam and Razzaq Ali, however, the victim girl has implicated Razzaq Ali of subjecting her to forceful sexual intercourse. She has also implicated the petitioner Abdul Malik of taking her to Kerala, wherein she was kept detained for 5 days. On the other hand, learned counsel for the informant has objected to grant of bail to the present petitioners on the ground that they are involved in the commission of the alleged offense and they have been threatening the informant number 2 to withdraw the instant case. Stop. I have considered the submissions made by learned counsel for both sides and has gone through the materials in the case diary. Though the learned counsel for the informant has also opposed the grant of bail to the accused Saidul Islam. However, victim girl in her statement made during 183 statement under section 183 of BNSS has categorically implicated Razzaq Ali and Abdul Malik. She has not made any incriminating statement against other co-accused persons. Stop. considering the fact that there are sufficient incriminating materials against the petitioner Abdul Malik, whereas no such materials could be found at this stage against the other petitioners. This court is of considered opinion that this is not a fit case where anticipatory bail may be granted to the petitioner number 3, Abdul Malik Ali, alias Malik Ali. Hence, his prayer for bail is rejected. However, stop, bail is rejected, stop. Moreover, as regards petitioner Abdul Razzaq Ali, alias Razzaq Ali, since he has been arrested, his anticipatory bail application has become infructuous. As regards the other petitioners, namely Saidul Islam, Mukhtar Ali, Muskur Ali, and Nashed Ali, as there are no such incriminating materials against them in the case diary at this stage, this court is of if they cooperate in the investigation, their custodial interrogation may not be necessary for fair completion of the investigation of Moirabari of Mayang PS case number 105/2024. In view of the above named petitioners, within brackets Saidul Islam, Mukhtar Ali, Muskur Ali, and Nased Ali are hereby directed to appear before the investigating officer of Mayang PS case number 105/2024 within a period of 7 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the condition, subject to the satisfaction of the arresting authority with following conditions. Condition 1 and 2, Abhishek or Pranali. This anticipatory bail application is accordingly disposed.
Lordship, because the vacation is coming from tomorrow, so date of receipt of the certificate copy of this order, 7 days from the date of receipt of the certificate copy. Because
15 days.
Yes, Lord.
Within 15 days.
Okay.
Item 44.
34, I'm sorry, Malak, CD not received.
Interim protection is there, madam.
Interim is there, Malak.
Heard Mr. M. Fukon, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed.
6th of November, Malak.
Let this case be listed on 6th of November. Till then, the interim protection shall continue.
Item 45.
35 also CD not received.
None has appeared for the petitioner on call. Learned additional public prosecutor has prayed for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on
6th of 11.
6th of November.
6.
None has appeared for the petitioner on call. Case diary?
CD available, Malak.
Whether he has appeared.
Yes, appeared.
Learned additional public prosecutor has produced the case diary of Jorhat Police
Jorhat
Station
PS
case number 172/2025 and has submitted that the petitioner has appeared before the investigating officer and his statement has been recorded under section 180 of BNSS. Stop. In view of the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to him by order dated 1/9/2025 is hereby made absolute
Versus stolen mobile money.
with condition number 1 and 2 attached to the said order remaining intact. This bail application is accordingly disposed.
Item 47.
We have appeared before the investigating officer.
Heard Mr. K.P. Pathak, learned counsel for the petitioner. Also heard Mr. K.K. Parashar.
This is malad appeared yesterday malad one dispose of one matter malad regarding the Janani Suraksha Yojana malad. One lady malad she taken money. She is helping her malad. Otherwise now appeared
Stop.
Her account was used.
Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court with certain conditions on 5/9/2025. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Learned additional public prosecutor has produced the case diary of Nikhil Mehta PS case number 107/2025 and has submitted that though there are some incriminating materials against the petitioner in the case diary, however, the petitioner petitioner is male or female?
Female.
She has appeared before the investigating officer and her statement has been recorded. Considering the submissions made by the learned counsel for both sides, and also the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to the above named petitioner on 5/9/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This bail application is accordingly disposed.
Deep blue.
Lordship, case diary has been received from petitioner appeared first.
We have appeared, my lord.
Heard Mr. K. N. Chaudhary, learned senior counsel assisted by Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. P. P. Datta, learned additional special public prosecutor. Learned senior counsel for the petitioner has submitted that the petitioner was granted interim bail by this court on 5/9/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Learned additional special public prosecutor has produced the case diary of Vigilance PS case number 22/2025 and has endorsed the submissions made by learned senior counsel for the petitioner. Stop. Since the petitioner has complied with the directions of this court and has appeared and has cooperated in the investigation, the interim bail granted to him on 5/9/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case.
Deep blue. Okay.
49.
That matter, my lord, I have my statement also recorded also, but my bail application was earlier rejected. Only because of condition number 1, I have violated, they have said, it is alleged, my lord. The thing is that no FIR has been registered, my lord. In case diary not received, but in the meantime, my lord, that annexure page 29 on the last in advanced stage, my lord. Only for on last Sunday also police has gone to my place, my lord, for arrest.
Where is your earlier rejection on?
That is on the page 23, 19/7/25,
Page number?
page number 23.
Now what is your ground?
Hello, new ground.
Yes.
New ground is there. No FIR has been filed. Earlier, my bail application was rejected because that FIR has been filed that I have inducement has been made, but no such, no FIR has been filed. I have inquired also my. I have inquired the para 7, I have stated much. Para 7, page 8. The petitioner begs to state that the case was fixed by the Honorable Court for case diary on 4/9/25. The Tarabari police station has submitted the case diary of Tarabari police station.
You were granted interim bail.
Yes, my interim. I have earlier interim when I appeared also, my statement also recorded. But only the thing is that clause number 1 I have violated, but there is not a fact, man. There is not a fact because no FIR has been filed. Para 7 I have stated, man.
No, filing of FIR may not be necessary in all
But here
cases.
that inducement, no inducement, my lord. But why shall I? Because 5 times already I have appeared. Before interim.
Yes, Mr. Parashar.
Yes, in the order, it is reflected that FIR also lodged before the Tarabari PS.
No.
But if it is not there, Malad, to ascertain that should be necessary. We have sent a signal and they have given Malad, we have received yesterday, Malad. CD could not be produced.
Only the things that my lord in the advanced stage, my lord, page.
Who's advanced stage? Your
Wife, my lord.
Your wife's.
I am the only person who have to look after her. Only for earlier also, my lord, I have my lord.
Where is the medical document?
That the annexer medical certificate is there. Medical officer at 10/9/25, page 29.
Page number?
33, last page.
Last page. Kindly, my lord. Otherwise, if
No, you mention the page number properly first.
33, last page.
Advanced stage.
Last page, my lord.
It is 20 weeks. That is 4 months.
20 weeks, another 2 weeks has gone, my lord. So 5 months and 6 months stage, my lord. And only I am the person looking, my lord. Only their ground. Because earlier all occasion I have also appeared. My statements also recorded, my lord.
Heard, Mr. Item number?
Item number 39.
39.
Heard, Mr. B. Sinha, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that this is for the second time the petitioner has approached this court seeking anticipatory bail. On an earlier occasion, though he was granted interim bail by the court in AB case number 1642/2025. However, later on 19/7/2025, by order dated 19/7/2025, his prayer for bail was rejected mainly on the ground. No, by order dated 4/9/2025, his prayer for bail was rejected mainly on the ground that
Condition number 1 is not complied.
that he had violated the condition number 1 attached to the interim bail order dated 19/7/2025. Learned counsel for the petitioner has submitted that on the last occasion, the counsel for the response, who stated that
The PP, my lord, PP.
it was submitted that an FIR has been lodged by the informant regarding threatening given by the petitioner to the informant. However, learned counsel for the petitioner submits that he has inquired And no FIR has been lodged, no subsequent FIR has been lodged against the present petitioner as mentioned in the
There are 7.
order dated 4/9/2025. He further submits that the wife of the petitioner is carrying pregnancy, advanced stage of pregnancy. And there is no one to look after his wife at this crucial stage. He further submits that he is ready to cooperate in the investigation, which he has earlier also done while
On 19/8/25, my statement is recorded.
while he was granted interim bail. He further submits that his statement has also been recorded by the investigating officer. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary to appreciate the contentions raised by the learned counsel for the petitioner, hence praise for calling for the case diary. Let the case diary be called for. 24. Release this matter on November
November.
7th of November. In the meanwhile, considering the submissions made by learned counsel for the petitioner, if the petitioner is arrested before arrival of the case diary, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2.
Highly applied.
List accordingly.
Highly applied.
48-41.
Charge submitted. Say.
You are on interim bail. Heard Mr. M. Ahmed, learned counsel for the petitioner. And in other case, Mr. A. Satya. Arfukon. Separate order. The learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court by order dated 18/9/2025, and in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Learned additional public prosecutor, while producing the case diary of Kolaigaon PS case number 30/2025, has endorsed the correctness of the submissions made by learned counsel for the petitioner. Stop. Since the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim.
In this case, charge sheet submitted.
Oh, sorry, sorry. Learned
The
additional PPA submission to Katini. Learned additional public prosecutor has submitted that though the case diary was called for, however, charge sheet has been laid bearing charge sheet number
47/2025 dated 29/8/25.
You have appeared before the. Yes, Mr. Ahmed. Have you appeared?
So that instruction I don't like. Actually.
Then we will dispose of it as becoming infructuous. POXO case, you will receive the summons. In view of,
So far as the petitioner is concerned, there is nothing against the petitioner.
we don't know.
Yes, Lord.
If we go by the FIR only.
Stop. Our petitioner submission কাটিয়ে দিব regarding appearance before the. Since the charge sheet has been laid in this case, this anticipatory bail application has become infructuous and accordingly disposed of. Same order in. You were also in.
Yes, I am
interim.
also on interim.
Interim.
Same order in case of 41 also. Council's name is R. Hawk.
Timing again 53. May I please look, in this case, the petitioner has been convicted under section 138 NI Act by the, my lord, Chief Judicial Magistrate, awarding, my lord, sentence and to undergo 1 year and compensation of rupees 3 lakhs. That has been modified, affirmed by the appellate court also, 138, under section 138, and sentence that will reduce to 1 year to 6 months, and award also 2,60,000. Now the ground of the revision is that the dishonor of check and the statutory provision that 138 A, B, C, D was not complied with. There is no demand. There was no demand. And another ground was that.
Heard
no-
Mr. B. Sinha, learned counsel for the petitioner. Also, state is not a party.
No, it is a completely private matter. Or your lordship.
No,
Direct, I will
not
make.
necessary. This application under section 438/442 of BNS has been filed by the petitioner, namely Pratima Datta Kolita, impugning the judgment and order dated 14/7/2025, passed by the Court of Learned Session Judge Golaghat in criminal appeal number 3/2023, whereby the conviction of the petitioner under section 138 of the NI Act by the judgment dated 21/2/2017 passed in NIK. Where is the case number? NI case number?
That is, my lord, page 56.
Passed in NI case number.
No, sorry, much. That is in page,
CRNI case number
Yes, madam.
9/2017. You should mention this in the cost item. That is the requirement of the rules. NI case number
oh, yes, sir, there is.
9/2017. Stop. However, the sentence imposed on the petitioner was modified to
SI of 6 months.
simple imprisonment for 6 months, as well as to pay a compensation of rupees 2,60,000 only. Stop. Let the records of the appellate court as well as trial court be called for. Let also notice be issued to respondent, sole respondent. The petitioner shall take steps for issuance of notice upon the sole respondent by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable on Putul date at the returnable on 11th of November. In the meanwhile, considering the fact that the petitioner has been sentenced to a short-term imprisonment of 6 months only, the execution of sentence imposed on the petitioner by the impugned judgment shall remain stayed till next returnable date. List accordingly. In IA, in view of the IA is for,
Yeah, IS for one is for bail or one is for suspension of sentence.
in view of the orders passed today in the criminal revision petition number 412/2025. This interlocutory application has become infructuous and accordingly disposed of.
And another I is there for bail matter. To remain on bail.
In the main case, you are on bail or not?
Yes, ma'am.
In the main case, Abhishek, in the main case, add one line. The petitioner is also allowed to remain on previous bail. In second, I also dispose of on becoming infructuous.
Right.
Taking cognizance of offense made against the company under section 138 of the Negotiable Instrument Act. And the petition process has been issued against the petitioner in the capacity of the managing director. The check was issued while the petitioner was the managing director of the company. The presentation of the check as well as subsequent been done while the petitioner has already resigned from the post of the managing director. This was duly communicated while replying to the notice under section 138B. Yet, the trial court has issued process against the petitioner. So first section 141 is concerned, offense by companies. Every person who is at the time of the offense was committed has to be in the charge of the affairs of the company. Here, accept the issuance of the check, subsequent all presentation, as well as the demand under section 138B, and failure to pay, etc. These have been while the petitioner has already resigned. Now, your lordship will kindly find the complaint is at page 45. It's a long complaint, I'll just take the relevant portion, Page 45, accused number 2. (141).
Now, where is that at the time of commission of offense?
Gotcha. Yes, the few dates lordship will kindly note. The check was issued on 28th of April 2019. Then petitioner resigned on 7/5/2019. Check was presented on 22/5/2019. Check was dishonored on 23/5/2019.
Okay. Heard Mr. P.J. Soikia, learned senior counsel assisted by Mr. A.K. Gupta, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Shri Chittaranjan Chakravarti, who is impugning the order dated 30/10/2019 passed by the Court of Learned Additional Chief Judicial Magistrate Dibrugarh in case number 105C/2019, whereby the cognizance of offense under section 138 of Enact, 138 of Negotiable Instrument Act has been taken against the petitioner, and processes were issued to him. Learned counsel for the petitioner submits that the respondent number 1 has initiated the aforesaid criminal proceeding accusing the petitioner of committing offense under section 138 of Negotiable Instrument Act as by issuing the check which was dishonored later on. In which capacity you issued the check? In the capacity of managing director of the Madar Khat Tea Company Private Limited. Learned counsel for the petitioner has submitted that though the petitioner, while he was still the managing director of the company, had issued the check in question on 24/2019. However, he had resigned from the said post on 7/5/2019. Whereas the check was presented to the bank for encashment on 20/5/2019, and on 23/5/2019 the demand was made. If learned senior counsel submits that before commission of the offense under section 138 of the NI Act, the petitioner had resigned as the managing director of the company, and therefore under section 141 of the Negotiable Instrument Act, the petitioner is not liable for the offense committed by the company when he was no longer in the employment of the said company. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, returnable on fixed date, 7th November. However, how many accused persons are there? Only you are the accused.
I'm the one and the company has
Company.
been made party. Company has
However,
not appeared.
However, in considering the submissions made by learned senior counsel as discussed in the foregoing paragraphs, further proceedings of CR case number 105C/2019 qua the present petitioner shall remain stayed till next returnable date, list accordingly.
Item 42.
Please, Lord. So it's a POXO case. We have taken steps on 13/5/2025. This report was awaited and the last date my learned friend was.
Yes, well, from our office, it was sent on 14/5, my lord.
Yes.
From our office, it was sent on 14/5. But till that, no, my lord, address, my lord, amicus may be appointed, my lord. Otherwise, we have not received instruction, my lord.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard, you are amicus?
No, appellant.
Sorry, heard Mr. S. Nawaz, learned counsel for the appellant. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the notices have been issued to respondent number 2, however, no service report has been received till date. It also appears that notices were sent to respondent number 2 in the month of May 2025. Considering period, considering the fact that after such a long period, no service report has been received, this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Any amicus in the court? This court accordingly appoints Ms. Priyanki Das, learned counsel whose name appear in the list of amicus curiae prepared by the registry as amicus curiae to defend the cause of respondent number 2. The applicant shall take steps for applicant shall furnish the copy of interlocutory application along with the memo of appeal to the newly appointed amicus curiae. The registry shall reflect the name of Ms. Priyanki Das as amicus curiae for respondent number 2 in this case. Let this case be listed
24th.
on 24th of September. October.
I'm deeply aware.
None has appeared. 43.
Lordship, as per office note dated 19/9, Lordship, the notice sent to the officer inserts is yet to be received, Lordship.
Heard Mr. S.N. Krishnatreya, learned counsel for the petitioner. As for office note dated 19/9/2025, the notices issued to respondent number 2 has not yet been served. It is a POXO matter.
No, Lordship.
Okay,
Against
okay.
on conviction day before appeal and appeal got dismissed against the dismissal day before the.
We'll await,
Yes, Lordship.
let the, no, await further. Let this matter be listed after.
Lordship, one small player, Lordship, that registry is directed to submit a track concern report, Lordship, because
Yeah, wait further. On the next date, registry is directed to submit the postal track consignment report of the notices sent to the to the respondent by registered post with AD. Let this case be listed on date at the view. 30 October,
Lordship, can it be on before or after 30th?
suggested date,
On
24th October.
obliged, Lordship.
Item 44.
Yeah, please, your lordship. Not in this case, in the IM minute, the second minute. So far the office note dated 24/9/2025 is concerned, it says that minute, neither the AD nor the service report or answer report came back. But so far as the track consignment report is concerned, minute, I have searched it minute online. It shows that the notice has duly been delivered to the.
Submit the track consignment. Learned, heard Mr.
Yeah, Aliban.
A. Ali, learned counsel for the petitioner. On, it appears that what this I is for,
It is for implement of minute parties. Because the respondent number 1 expired minute and then respondent 2 and 3, that is the son and the wife minute. They are sought to be implemented.
that neither the AD, it appears that from office note dated 24/9/2025, it appears that neither the AD card nor the unserved notice in respect of respondent number 2, 3, and 4 have been received back. On the other hand, learned counsel for the applicant submits that he may be allowed to submit the track consignment report of the notices sent to the aforesaid respondent on the next date fixed. Where is allowed. Let this matter be listed on 30 October.
Obliged.
Item 45.
May I please, Your Lordship?
Yes.
Lordship, since Lordship, the criminal revision petition, Lordship delays their Lordship ex parte order, Lordship. And since the proceeding is start, Lordship, the petitioner never appear before the trial court, Lordship. And the case is filed by the respondent number 2 in under section 125 CRPC, Lordship. So, my lord, 216 days delay, Lordship, for filing this
Heard
petition.
Mr. A for learned counsel for the petitioner. This application under section 5 of the Limitation Act 1963 has been filed by the applicant Ankur Sarkar, praying for condoning the delay of 216 days in preferring the connected criminal appeal,
Revision, Lordship.
criminal revision. Stop, issue notice to the respondent.
By one submission, Lordship. Sorry, Lordship. The petitioner never appeared before the court below, Lordship.
No, but
That is the
notice,
case,
will
Lordship,
notice
but-
have to
but-
go.
And ex parte order, Lordship.
Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order. Returnable on 31st October.
They will be condemned that because ex parte and he is totally unaware about.
Now, what is your submission?
Proceeding to.
Notice should not go. Is that your submission?
Lordship, the
You should be clear in your what you are submitting. Instead of murmuring, you should be clear. Because I am not getting your submission. Notice has to go in a condonation letter. Yes.
obliged.
Service report was awaited, madam. Criminal
Heard Mr. S. Nawaz, learned counsel for the petitioner. What should we do? Wait,
Steps were taken on 12th of August, my lord. So one opportunity.
okay. On perusal of the office note is there.
Regarding our taking of steps is there, but not regarding anything about service report being awaited. Because it is rooted to the petition.
It appears that though the steps for issuance of notice on the respondent number 2 has been taken by the appellant / applicant. However, no service report has been received till date. Await further. List this matter.
They may obtain like instructions when.
The POXO is there.
POXO is there.
Okay. Learned and additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fixed. List this matter again on
24th.
22nd of
24th.
24th of September, October.
I'm detailed.
Item 65.
Lordship, in last occasion, this honorable court has directed me to rectify for 9 days delay for condonation of the petition your in limitation act, your lordship.
You have rectified.
Yes. That it,
Who is the other side? State.
for us,
You are not objecting. Heard Dr. B.N. Gogoi, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed by the applicant, Sri Jayanta Das, praying for condonation of 9 days of delay in preferring the connected connected appeal,
Lord, revision, sir. Your Honor.
connected revision petition. Whereby the appellant, whereby the which order you are
Your Lordship, 12/8/2024,
passed by?
passed by Your Lordship CGA, Jorhat.
You have not preferred revision before sessions court.
Yes, you had filed here on, that is on Your Lordship on 25. Page 25 to 54.
Where is the order of the sessions court?
Lordship in page 62. 22/5/2000, start from annexure for 61, Your Lordship.
Whereby the applicant intends to impugn the order dated page 62.
61, Your Lordship, starts from 61. Date of judgment of 22/5/2025, that is the order.
What are you saying? There is no, where is the order
Lordship.
which you are impugning?
That is on annexure 4, Your Lordship,
Page number?
page number 55.
You are not, I have to adjourn this matter again. You are not able to properly mention the page number. 17.
Correct. 17.
Judgment dated 22/5/25, passed by the Court of Learned, Session Judge Jorhat in Criminal Appeal number 2024. Since the delay in preferring the connected criminal revision is only of 9 days, Learned additional public prosecutor does not opposes the condonation of the same. Further, the grounds shown for approaching this court belatedly after 9 days of the prescribed period of limitation appears to be sufficient grounds. Hence, the prayer for condonation of delay of 9 days in preferring the connected revision petition is allowed, and this interlocutory application is disposed of. The registry is directed to register the connected revision petition and list the same for admission. List the same for admission on a date to be fixed by it. It will come in admission or motion.
Admission.
Admission. Production.
Item 20.
Yes.
Your Lordship, this is an appeal against the order of the conviction and sentence passed by the learned additional session judge FTC Sunitpur in session case number 91 of 23.
In
related to deputy case
main
number
appeal
5.
heard Mr. S.C. Bishwas, Learned Counsel for the appellant. This appeal under section 415 of the BNSS has been preferred by the appellant, namely Shri Sujit Chandra, impugning the judgment and order dated 1/8/2025, passed by the Court of London Additional Sessions Judge within bracket FTC Sonitpur in Sessions Case number 91/2023, whereby the appellant was convicted under section
324
324 of
and 307
of Indian Penal Code and was sentenced
to
to
5 years.
undergo rigorous imprisonment for 5 years
And-
and to pay a fine of rupees 30,000 in default of payment of fine, to undergo simple imprisonment for 6 months. The appellant was also convicted under section 307 of the Indian Penal Code and was, what is the sentence of 307?
Total 5 years.
And was sentenced to undergo simple rigorous imprisonment for 5 years. In both the offences, same punishment.
307 part 2, madam. 307 part 2, and he is imprisoned for 5 years and to pay a fine of 30,000.
And in 324,
324. Guilty under 324 and 307, madam. Convicted him under section 307 part 2 IPC.
no separate sentence was imposed for
No, madam, nothing.
324 and
Yes.
stop.
There are 70 of my judgment, madam, page 76 kindly, peruse.
Let this appeal is admitted for hearing. Let the records of the trial court be called for registry to take steps for requisitioning the trial court records. List after receipt of trial court record.
But there is the IA, madam.
This interlocutory application under section 430 of BNSS has been filed by the applicant Sri Sujit Chanda, praying for suspension of the execution of sentence imposed on the appellant, imposed on the applicant by the judgment and order dated 1/8/2025, passed by Learned Session Judge Sonitpur, Additional Session Judge
FTC.
FTC Sonitpur, Tejpur in Sessions Case number 91/2023. The aforesaid judgment has been impugned by the present applicant by filing the connected criminal appeal number 368/2025. I have also heard learned additional public prosecutor. Since the sentence imposed on the applicant is a short-term sentence of 5 years only, the execution of sentence imposed on the applicant by the impugned judgment is hereby stayed during the pendency of the connected criminal appeal number 368/2025. You are on bail.
No, madam, I am inside. That's why I am before.
The petitioner is also allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Additional Session Judge Sonitpur,
FTC.
Additional Session Judge within bracket FTC Sonitpur in Sessions Case number 91/2023, subject to the condition that in event of dismissal of connected criminal appeal number 368/2025, the applicant shall surrender before the trial court to serve out the remaining part of sentence imposed on him by the impugned judgment. This interlocutory application is accordingly disposed of.
No problem.
Production.
Product only, item one for withdrawal.
Heard, Mr. D. Chakravarti. T. Chakravarti, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
I'm obliged. Item two,
More.
similar prayer,
Two same order.
1 and 2. I'm obliged, ma'am.
Item three,
Same order, counsel on naam bail active. What is your name?
NM
N.
Ali.
NMLE. Order is same, dismissal on withdrawal.
product only, item four,
Wait, Lordship. Lordship, in this case, FIR page 16. Lord, there was online fraud, my lord. A FIR says 4 parts, name of 4 persons, my lord. One is, my lord, page 16. Accordingly, an inquiry was launched. In this regard, during inquiry, it was found that the accused individuals, namely Asadul Islam, Hasanur Zaman, Kubat Ali Mullah, along with one Hikmat Ali and others involved in a cyber crime.
Kesdari would be required. Heard Mr. M.R. Khandokar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. All for the case diary. Let this matter be listed on 30 October,
My lord, it can be 15 or 16, my lord.
16 October,
16, my lord. 16, my lord.
22nd October.
item five,
17.
No, it will go to November then,
My lord, since vacation is there.
22nd, 17 October.
I'm the.
This matter came before Lordship, I did not, this matter, out of same FIR, your Lordship would have page 21. This will make clear, madam. A child was born 15 days child, madam. Allegation is that he was sold to someone, madam. And though someone came before Lordship and they got a B, my lord, page 20, 19 and 20. And I am the person, allegation is that I am sold it to them. Our parents already arrested, not parent, father, no? Father already arrested.
Who are you?
I am none of them, my lord, I am a villager. But allegation in the FIR is that I have sold it to 2 persons who are already they got paid in this order, my lord. And now section, no, today is 65 days, my lord.
You are behind the bars.
Bar.
So my submission would be for calling of the case diary also, because if Lordship kindly reduces the FIR also.
Yes.
The main allegation is against the present petitioner also. He sold the infant child Lordship to the other person, and Lordship here the attributed section imprisonment for 143 for life. It carries life sentence.
143.
Subsection
Kindly
4.
see 143, my lord, whether it is applicable or not. My lord. I am not on that, my lord. Your Lordship mentioned these sections are not applicable. In that case, my lord. Kindly have a look to page section, my lord, 93 and 143A. Oh, BNS. Ninety-three, my lord.
Yes.
FIR allegation, my lord, 93, expose or abandonment of child. It is not manner applicable in present case, my lord. Exposure and abandonment of child under 12 years of age by parent or person having care of. Then section 143, my lord, trafficking.
143 subsection 4.
Yes, subsection 4. Now, meaning of trafficking, my lord, you will kindly see 143 subclause 1. Then 4 will come. Whoever for the purpose of exploitation recruits, transports, harbors, transfers, receives a person or person by using threat, using force, abduction, practicing fraud, abuse of power, inducement, is the trafficking of traffic. Now, kindly see the FIR, my lord and friend, kindly see the FIR, what is the language of FIR? None of them falls under this. At best, I find it comes under 81 of juvenile justice. Here it is 80 they have given, but along with juvenile justice act, my lord. The kindly have looked at FIR, my lord, only 2, 3, 4 lines, my lord.
Yes, well, which page?
Page 9.
Type copy.
1 page, man. English concern. Oh, English. It is English, my concession. In inviting a reference to subject above, I am to inform you that on 23/6/25, the DCP, I mean, my lord, Child Protection Officer, my district, received a complaint through regarding an infant child of 15 days of Abdul, my lord, son of Abdul. He is already behind the bar, already arrested. Abdul. District Hailangandi was illegally adopted by a couple, namely Javed Ahmad Lashkar, said that your lordship's order, AB. These 2 persons, man. Adopted by a couple, namely so and so. The concerned child was illegally sold to the above mentioned couple by a person named Zakaria, present petition. Concerned child was illegally sold to the above mentioned couple in so and so. Currently, he is staying at Kabugan near so and so, where he is running a restaurant. Accordingly, forwarded the request letter so and so. Then officers of child helpline will now in the custody of the child welfare committee. Everything seized, my lord, purpose, for the custody. It does not fall at all under any of the sections. If at all, it falls under 81.
What is 81?
So my submission would be, lordship, exactly for that reason, lordship, the perusal of the case that is required, lordship, because it is stated, lordship, that he sold the child, lordship.
That's true.
Now, the transaction involved, lordship, that will have to be perused by lordship. Because
No, assuming that he sold it.
yes,
Still, he is behind the bars for how many days? 60?
65 days, my lord.
even then, lordship, the.
No, even then, what is the purpose of keeping him?
Lordship, let me submit, lordship. I'm just trying to submit.
Yes, yes,
You
yes,
cannot interrupt me.
No, no, yes, sir.
Please don't interrupt.
I'm just submitting, lordship.
You are free to submit.
I'm submitting, lordship.
That is also an interference.
No, my lord, I am just.
Yes.
That's right, sir.
And now, lordship, the section that has been attributed, lordship, it relates specifically to trafficking of a child. Now, they are saying, lordship, that this section is not attributed. Now, to understand that, lordship, the child was sold, lordship, it was recovered later. He is a person, lordship, who is nowhere related to the other persons, nor to the parents, nor to the receiver, lordship. What role he played, lordship. And that section, lordship, that is attributed, that carries a punishment, maximum punishment, lordship. So, lordship, considering that aspect, lordship, I am praying for perusal of the case by lordship. Because,
No,
lordship,
but
the other co-accused, he is in a different footing. The transaction was initiated and completed by the present petitioner, lordship. He is the person who had done the transaction, lordship.
no, he as well as the person who are granted bail
Yes.
stands on same footing.
In my respect, lordship, because they.
No, because
Yes.
the offense under section 143(1) is for transferee and transferor as well as receiver.
Yes.
So receivers got bail. Transferor also stand on same footing or not?
So the transfer regarding that, it is specifically mentioned, it was illegally adopted, lordship. The purpose with regard to the other co-accused is, lordship, that it was for adoption means, lordship. Now, lordship, he sold the child, lordship, he is in a different footing, lordship. Because, lordship, he should understand, lordship, that cannot be done, lordship. A child, as 15 days child, lordship, he was sold, lordship. Whether he received monetary benefit, lordship, in that transaction, that has to be ascertained. And whether, lordship, this transaction is.
This is the first bail application.
And where is the rejection order?
Your first bail application.
Hospital, unlisted, my lord.
Okay, we are
And the question is there, that's why. my lord.
calling for the case diary
That's
immediately,
your lordship can say. Then
immediately on
interim may
reopening.
be given, my lord. Even regular bail also. But your lord, on the face of it, my lord, whether 93 or 148, whether it is applicable in my case, it is neither adoption. No sale, my the person who adopted, who purchased, they got bail, my AB. For the integrity of
Yes,
justice, my lord,
one query, it has to be for the purpose of exploitation,
Yes.
where is that?
whether
That lordship, the case diary will speak lordship. Lordship, the monetary angle, whether there is any monetary angle, what was the purpose lordship, the statement of the original parents, that has to be perused lordship.
yes,
And this is. not
because
affected-
father is behind the bar.
Father is behind the bar. What remains, my lord? Father is behind the bar. The person who adopted, who had my purchased from me, they are also interim, my lord. The what remains, my lord?
That is why lordship.
Everything is there, my lord. Child is in the custody of the.
Heard Mr. H.R.A. Chaudhary, London Senior Counsel, assisted by Mr. I.U. Chaudhary, Learned Counsel for the petitioner. Since this application for bail has been filed by the petitioner, namely Zakaria Ahmad Barbuya, against whom the accusation of selling an infant child belonging to Abdul Rauf Laskar has been made. Since the said Abdul Rauf Laskar is still behind the bars, this court intends to peruse the case diary before considering the application for bail of the present petitioner, against whom accusation of selling the said child has been made. List this matter for call for the case diary.
Vacation court,
No, vacation court, you have to mention.
written my.
No, vacation court, you have to, there is an SOP. How to list the matter before vacation court.
Your lordship may fix also, my lord, or two system, one is fixed, other is we can mention also. my lord.
No, only one system is there. As
That I
per
have not
us,
seen there, so.
SOP only one system. I am fixing it after puja vacation. You can mention before vacation court after following the system.
That's maybe my lord, otherwise if your lordship fixed after vacation, then I cannot mention also.
Okay. Let this matter be listed after puja, no, after puja vacation on 17th October. However, the council, learned senior counsel for the petitioner is given liberty to mention the matter for listing before vacation court in person to the SOP issued in this regard by the registry.
City also, my lord.
Yes, I have called for the case.
Always.
This is for the, my lord, second bail application. And my lord, earlier bail was rejected under certain changed circumstances.
Under
Lordship-
fiction?
Pardon, my lord. Second bail application under certain
Where
changed,
is the rejection order?
lord, at page, my lord. At page 105. I am not the name accused person. And only on suspicion I was arrested on an earlier occasion, my lord. Of course, that ground was taken. And after perusing the, my lord, CD, my lord was not inclined to grant any bail. Now the petitioner, all other persons who were apprehended and arrested, they were granted bail. And in fact, my lord, a demand draft of rupees 70 lakhs, which was
What
issued-
is your new ground?
My lord, Notice, lordship, I issue notice.
We will issue.
On new guy, my lord, he is, my lord, at the moment, he is suffering from, my lord, heart problem, my lord.
But you are a free person.
That's right, my lord.
We'll issue notice.
Fine.
Heard Mr. A.K. Purkayastha, learned senior advocate, assisted by Mr. What is your name?
Round high, my lord. Naam to koi diya.
Mr. P.K. Kolita, learned counsel for the petitioner. Also at Mr. B. Sharma, learned additional public prosecutor. Call for the case diary. Let this matter be listed. 24th of October.
My lord, wish you, my lord, for the puja vacation, my lord.
Yes, same to you.
7.
May I please, your lordship. Herein a notice under section 35 has been served to the petitioner, your lordship. That notice is this 16, your lordship. It is this 16, your lordship. And the petitioner received it on 10/9/2025. And by this notice, the petitioner
10/9, what is the date? Date of
within
it.
7 days, your lordship, I was asked to appear.
Whether 7 days has left.
7 days has left. But
Oh.
120, the mail was sent by the petitioner. But no response has been received.
What is the accusation?
Accusation here in 318 subsection 4, 336 and 336(4), 338, 54 and 61 subsection 2. Further is sitting your lordship.
Okay, firstly, lordship, the notice is dated 26/7/25.
Where is the notice?
Date 16. This is the type copy, lordship.
Notice first.
Where you have to appear?
Gujarat, your lord.
And other thing, lordship, one more submission I would like to make, lordship.
But whatever may be your lordship, but this notice was received on 10/9/2025.
Lordship, does it mean whatever may be that, lordship, that I cannot submit, lordship, is that is meaning? I don't understand it.
Yes, this tendency of interrupting while one counsel is submitting, it will weaken your case. Because grant of bail, that too anticipatory is discretionary.
I'm sorry.
If your conduct is not proper, on that ground itself, your client may suffer.
I'm extremely sorry.
Yes.
Yes, lordship, lordship is perusing page 16, lordship, the notice. Lordship, kindly find in the first paragraph itself, I undersigned so-and-so of Gujarat, so-and-so cyber crime police station under section so-and-so, Information Technology Amendment Act 2008. Your Jana Small Finance Bank Limited account number so-and-so, IFC code so-and-so is found to be involved in this FIR. Complainant has been cheated in the name of investment, fraudulent money was circulated part through your Jana Small Finance Limited account number so-and-so, IFC code so-and-so. During the course of investigation, it is revealed that there are reasonable grounds to question you for ascertaining facts. So, lordship, the involvement is regarding his monetary transaction, lordship, his account is also specifically mentioned, lordship. The transit bail is okay, lordship, I have no issues with that, lordship, but he has to show some reasonable ground, lordship, for availing the transit bail.
Yes.
It is not that, lordship, that he will file a transit bail and the court will have to give him transit bail.
Yes.
In my petition, your lordship, I had stated that the mother of the petitioner here, due to her old age, your lordship, she has been suffering various ailment, your lordship.
Therefore, you could not.
Yes. He will definitely approach before.
Priya Indoria.
Priya
Heard
Indoria.
Mr. A.M. Khan.
Sorry, lordship, one more submission, lordship. This is not the one incident, lordship. Another matter has been filed by the same petitioner in respect of another case in another state, lordship.
Another state.
Yes.
I have the petition also. Lordship. That is from Lordship Telangana. It appears Lordship he is involved in this type of offenses, Lordship, prima facie Lordship.
In fact, your lordship, in here, the petitioner, he is the proprietor of a company, your lordship. And that company was, an agreement was executed. That is that annexed
No,
to your.
no. For getting transit bail, we are not going into merits, but you have to satisfy why you cannot go before the court having jurisdiction over the subject matter. This is a case of Gujarat. You have to approach before the appropriate court within reasonable period of time.
In this petition, your lordship, I have stated that the mother ailment, your lordship, that has been stated hearing.
We are
In
granting
support of
him
that, your lordship,
limited. Heard,
10 days, Lordship.
heard Mr. A.M. Khan, London, counsel for the petitioner. Also heard Mr. B. Sharma, London additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner seeking transit bail under section 482, seeking transit bail in connection with what is the case number? Cybercrime PS case number 111960402500027/2025 under section 318 within bracket 4, 336 within bracket 3, 336 within bracket 4, 338/54/61 within bracket 2 of BNS, read with section 66D of the Information Technology Act. Learned counsel for the petitioner has submitted that the petitioner is a resident of Amalpur,
Baksha.
resident of village Nij Kaurbaha under Tamalpur police station in the district of Baksa, Assam. However, he had received one notice under section 35(3) of BNSS in respect of the aforesaid cyber PS case, whereby it was informed to him that his bank account is involved in an FIR where the accusation of cheating in the name of investment has been made. And therefore, the petitioner was asked to appear before the investigating officer of the aforesaid case in Panigate Police Station, Vadodara City, Gujarat. Learned counsel for the petitioner submits that though the notice under section 35(3) of BNSS has been dated 26/7/2025. However, he received the said notice only on 10th of September 2025. He further submits that since the mother of the petitioner is suffering from various ailments, he could not appear before the investigating officer of the aforesaid case within the time prescribed in the said notice. Neither he could approach before the jurisdictional court to seek appropriate relief in this case. He further submits that since the aforesaid case is pending in Vadodara police station in the state of Gujarat, some interim protection may be granted to him so that he can he can appear before the investigating officer of the aforesaid case and also approach the jurisdictional court for seeking appropriate relief in that matter. On the other hand, an additional public prosecutor submits that the petitioner is found involved in more than one cases of similar nature where accusation of cheating general public in the name of investment of money has been made. He submits that the other case of the petitioner is in the state of Telangana. Any other submission? It's in the state of Telangana. Stop. I have considered the submissions made by learned counsel for the petitioner. Since the cause shown by the petitioner for his default in appearing before the investigating officer or approaching the jurisdictional court appears to be a just cause, and therefore in accordance to the guidelines of the apex court issued in the case of Priya Indoria versus State of Karnataka and others, reported in 2024 4 SCC 749, the petitioner is granted interim protection, that is transit bail, till
20
which date?
20 days, your lordship, I'm taking here.
Suggested date. Till 20 September. Till 20 September 20 October 20 October is okay. 20 October 2025. He is directed to appear before the investigating officer of the cybercrime PS case number Agod to case number Dibu, and cooperate in the investigation before the said date. If he does so, in the event of his arrest, he shall be allowed to go on interim bail till 20 October 2025. Stop. It is made clear that the relief granted in this case is interim in nature and shall be operative only till 20 October 2025. This anticipatory bail application is accordingly disposed of.
Your lordship, I have a small fear in production, just, I don't know, none, your lordship, for the extension of time, your lordship.
What is your matter?
So, your lordship, 122, my criminal petition was disposed of by directing that
Item number
9.
I'll pass orders in chamber.
Item 23, my lord. My lord, remain left over thrice, my lord. Your lordship directed me to submit short, my lord, argument. I prepared, my lord.
I am for the respondent, lordship.
What is the matter?
My lord, this matter, my lord, the Calcutta court, my lord, issued warrant of arrest, my lord. Everything here, my lord. My Guwahati, my lord, jurisdiction. My
You have also prepared.
Last occasion I submitted.
Item number?
23.
23.
23. Heard Mr. S. Chauhan, learned counsel for the petitioner. Also heard Ms. M. Sharma. Sorry, S. Yasmin, learned counsel for respondent number 1 to 2, 1 to 3. Both the council have submitted written gist of their argument in pursuant to the directions given to them by the last order. List this matter for delivery of orders on after puja. On 17th October.
Lordship, regarding item 21, Lordship, it is appeal against conviction for 1 year, Lordship. I'm outside, Lordship, only that, Lordship, suspension.
No, I cannot take load beyond what I may carry.
Because Lordship, otherwise, Lordship, next 30 is the date for final order, Lordship. Though I have allowed to refer appeal accordingly, Lordship, I prefer appeal before this court, Lordship.
What is the date?
Date 30 of this month, Lordship.
Item number?
21, Lordship. 1 year conviction, Lordship, under 354, Lordship, IPC.
Anything? Okay, I'll pass orders in chambers.
Highly obliged.
Make Lordship, with regard to item number 16, Lordship, on the last occasion, the matter could not.
Item number?
60, Lordship. This is also appeal against conviction, Lordship. And item number 60, Lordship.
Yes.
Lordship, the petitioner was on previous bill till today, Lordship. The petitioner has, the appellant has appeared today, Lordship, but the next date not aware, Lordship.
What is the sentence?
2 years, Lordship, rigorous imprisonment, Lordship, under section 498 IPC.
Okay, I'll pass orders in chambers.
Item number 18. The criminal appeal was already being applied. The IA was to be considered.
How much punishment?
8 years punishment.
8 years. After puja vacation.
The 6th occasion, the matter has reached
Suggested date.
on 16th of 17th, 15th.
Item number 18 on C. Due to paucity of time, this matter could not be taken up today. Please this matter on 16th of October.
That's all. Happy Puja vacation.
Same to all of you. Yes, Mr. Majumdar. Anything?
Lordship, item number 19. In this case, appellant was convicted on the wrong device that he pleaded guilty. Actually, he admitted that
How much punishment?
10 years, Lordship,
After
without
pu-
any trial,
After
he was
puja-
convicted.
After puja vacation.
Any date, Lordship?
No date.